Good morning, everyone. We'll resume the hearing of submissions on the urban growth chapter of the Selwyn District Plan. And just before we hear from our first submitter to the Section 42A reporting team, anything for us this morning? No? Okay, right. Good morning and welcome to the Carter Group.
Thank you. Thank you for having us back again. I am conscious that the last time we appeared and gave some oral submissions on the vexed issue of the interface between the NPSUD and the Regional Policy Statement of Void Policy, I think was at Strategic Directions. And as a result of some questioning at that hearing, there's been a flurry of papers between lawyers since that point in time, which I assume the panel have all read. So I don't intend to labour all of the arguments that are going back and forth various ways. I'll do a summary of it. As I understand it, Carter Group and various other parties and similarly, the Council's own legal advice adopts one interpretation and the City Council and Environment Canterbury adopt another. Since we appeared at Strategic Directions hearing, we've had for Carter Group 3 plan change hearings relating to plan changes to the operative district plan, and that Commissioner has issued one decision so far, but that's in the context of industrial land, which is also land which is subject to a rezoning request in this process. There's been, Carter Group has had 2 reasonably significant hearings with respect to rezoning for land to residential at Rolleston and last week at Lincoln, and we're hopeful of decisions on those before Christmas. But at least there will be a view from a commissioner as to some of the issues that are confronting the panel. And there's also a decision on a residential rezoning at West Melton, which may be the first one off the block, I think, to consider the issue because it was heard relatively early. So there may be at least a view from a commissioner in the Selwyn context that might be available to the panel before Christmas. So that's a long way of saying that I've been appearing in a number of hearings addressing this issue. Mr. Wakefield for the City Council and I think Wynne Williams have also come to that hearing commissioner with some sort of argument. I'm conscious we haven't had it addressed orally yet in front of you. So I'm happy to give you a summary or answer questions, whatever way is the best way of you dealing with it. But I am just conscious that there's been a lot of paper and I haven't actually synthesised it verbally in front of you yet. So I'm in the hands perhaps of the chair as to how you'd like to deal with this issue.
So you've pre-circulated a synopsis of your legal submissions. Maybe if you just go through that.
Thank you. Yeah.
Preferably probably read most of it out unless there's some quotes and things you can just skip over.
Yeah, I'm conscious of not too much and not too bit like Goldilocks, not too much and not too little, but conscious that this panel hasn't heard it yet, or at least from me. So
just before you do it though, who's the commissioner who's heard
so that's David Caldwell. And so just so if you know what he's got in front of him, he has heard and issued a decision on Plan Change 66, which is rezoning of land here at Rolleston. It was an application by Carter Group, and that's for land to be rezoned to industrial. That's just next to the I port. So there is some sort of indications in that as to where he's heading, but that particular application is in the context of industrial, so it's slightly different from where the battle's really coming out. He has then heard West Melton, which is another developer, Rolleston, which is Carter Group, and which is PC 73, PC 69 at Lincoln last week, which is some 2,000 odd sections. And he has also heard the plan changes that are to implement into the operative district plan the future development areas identified in PC1 through the RPS. So he's heard those as well. They're in a slightly different category because obviously the City Council, and he can say those ones are anticipated, where the ones we've dealt with would be unanticipated in terms of Policy 8.
And what was his decision on PC 66?
I've got a copy of it here. He has granted the decision in terms of PC 66. That one had to address the issue of whether, in the context of industrial, this particular application was going to add significantly to development capacity. So it had to address that question, i.e. is there enough industrial land zoned? So it was in a slightly different context. So I think the rubber's really going to hit the road on the first residential decision. He has closed the West Melton plan change hearing. And so I think we'll expect a decision on that in the next few weeks. Thank you. So I'll start down at paragraph 5 of my synopsis. The roughly what I'd call together Carter Group submitters. The submitters are generally supportive of the provisions in the urban growth chapter of the proposed plan. However, they seek the following additional changes from what was recommended in the officer's report. Firstly, that either the urban growth overlay and references to the overlay throughout the plan be deleted altogether, or alternatively, that the plan is reworded so that all references to the urban growth overlay are moderated and do not preclude urban growth beyond that urban growth overlay where that is appropriate based on a merits assessment, for example, where a particular proposal might meet policy 8 of the NPSUD. What we're saying that that's not every plan change, that is plan change that would have to meet the two limbs of adding significantly to development capacity and demonstrating a well-functioning urban environment. There are also some minor amendments to the definition of housing bottom line and urban growth P11, P11, which Mr. Phillips will take you to. So dealing with the key issue that the panel has to grapple with, in paragraph 7, in essence, the submitters are arguing that the plan should not include an arbitrary line which determines where urban growth should or should not occur, and that the urban growth overlay is currently drafted does that through policy P3, where it says avoid the zoning of land to establish any new urban areas or extensions to any township boundary in the Greater Christchurch area of the district outside the urban growth overlay. We understand that the urban growth overlay is, and the drafting of the avoid policy is, a reflection of the regional policy statement, in particular map A and objective 6213, which requires Greater Christchurch to be rebuilt through a framework that avoids urban development outside map A express effectively. Obviously, a proposed district plan has to give effect to a regional policy statement. However, we say that in the present case, to do so in the way that's currently proposed would be potentially inconsistent with the NPSUD. Now, we accept there is a potential inconsistency between Objective 6 of the RPS and Policy 8 in particular of the NPSUD and Objective 6213 of the RPS that needs to be addressed before the appropriate relief on the urban growth chapter can be identified. So what I'm saying is the panel is going to need to grapple with this interpretation issue first. Policy 8 of the NPSUD, which came into effect long after Objective 6213, provides that local authority decisions, and we say your decision on this plan is one of those, affecting urban environments must be responsive to plan changes. And we say this is a plan change that would add significantly to development capacity and contribute to welfare functioning urban environments. And Policy 8 says you must do that even if the development capacity is unanticipated by an RMA planning document. We say that you might as well read Policy 62.1.3 into A, because clearly any development which is outside map A, line on map A, is unanticipated by the regional policy statement. It is well established in the context of RMA planning documents that the word avoids means not allow or prevent the occurrence of. And that effectively means that if we interpreted the RPS alone, as it was before the NPSUD came into effect, a local authority cannot under any circumstances allow urban development outside existing urban areas or outside the greenfield priority areas on map A. I might just stop here and interpolate. It's always been a bit of a bugbear of mine that, and I've said it myself in these submissions, that we take the interpretation of a void in the context of the coastal policy statement and the King Salmon case and say, well, that's always how it needs to be interpreted in an RMA planning document. That may well be the case if you are interpreting an RMA planning document on its own. But the interpretation exercise that the panel has here before it is quite different. It's trying to reconcile two planning documents and make sense of two documents being read side by side, one which is higher order than the other and one which is later in time than the other. And that is quite a different exercise than what the Supreme Court was going through in King Salmon when it was trying to decide what the word avoid meant in the context of the particular document that it had in front of it. I say in paragraph 13, policy 8 of the NPSUD requires local authorities to be responsive to plan changes. And as Mr. Phillips will point you to, the Ministry for the Environment's guide on understanding and implementing those responsive planning policies, that the intended effect of policy 8 is that it limits a local authority's ability to refuse certain private plan changes without considering evidence, i.e. is it adding significant development capacity or contributing to a well-functioning urban environment. Such requests do need to be considered on a case-by-case basis against that criterion policy 8. It will likely lead to proposals being brought forward for development in greenfield and brownfield locations, which council planning documents have not yet identified as growth areas. Where local authorities choose to identify in RMA planning documents where they intend development to occur, that should not represent an immovable line. And regional policy statements and other planning documents will need to be reviewed and in some cases amended to reflect the responsive planning policies of the NPSUD. Currently, with the way Objective 6213 in the RPS is drafted, it does not allow local authorities to be responsive in the way intended by the NPSUD. That is, if you read the objective on its own and out of the context of the NPSUD, therefore does not give effect, and arguably that is contrary to the NPSUD. So in paragraph 16, I set out how this inconsistency can be reconciled, i.e. how these two documents can be read together. In summary, the following well-established principles of statutory interpretation should apply and assist. First of all, any interpretation exercise requires a purposive approach and consideration of the context surrounding a word or phrase. And that's why I say just taking the word avoid out of King Salmon and saying this is what it means is not the end of the exercise. Generally, the meaning of a plan can be ascertained by its words, plain and ordinary meaning, the test being what would an ordinary reasonable member of the public examining the plan have taken from the planning document. Where an interpretation creates an injustice, anomaly or absurdity, then it would be appropriate to look at the words in context and if required turn to other principles of statutory interpretation for guidance. And the last two are particularly important in the context of the interpretation exercise here, which is trying to read two documents together. Where there is an apparent inconsistency between two documents, the courts or decision makers will try very hard to reconcile the inconsistency and allow both provisions to stand together. But where there are two provisions that are totally inconsistent so that they can't be reconciled in a way that they can be read together, then it is appropriate to look at the doctrine of implied repeal. And the doctrine of implied repeal provides that the provision that is later in time impliedly repeals the earlier provision. However, that is a doctrine of last resort and should only be applied where all attempts at reconciliation have failed. It is also widely accepted that the RMA provides for three-tiered management system of national, regional and district documents. This establishes a hierarchy of planning documents where lower order documents must give effect to higher order ones. Within that hierarchy, that there can be no argument that the national policy statement ranks higher than the regional policy statement. So, Reconciling the potential inconsistency between the two, we submit that adopting a plain and ordinary meaning interpretation in the context of interpreting the RPS on its own would not reconcile the RPS with Policy 8 of the NPSUD and would lead to the type of problems, namely anomaly, absurdity, identified by the High Court in Powell. Namely, the interpretation would be contrary to the very purpose of Policy 8, would prevent the NPSUD from achieving its very purpose, and would interpret the word avoid in a vacuum and outside the context of reading the RPS and the NPSUD together. As the panel will be already aware through our memorandum on strategic directions, we consider the inconsistency can be reconciled without the implied repeal of the RPS objective. In doing this, we consider it highly relevant that the NPSUD provides a clear national level direction to enable development capacity and is a higher order document than the RPS in terms of the resource management hierarchy. So it informs the interpretation of the lower level document, and also the NPSUD is the most recent in time. As such, given that the NPSUD is A, higher level, and B, later in time, we say it is appropriate to read down or soften the interpretation of avoid in the RPS to mean it has to also give effect to the NPSUD, or at least until such time as the RPS is amended to give full effect to the NPSUD itself. This can be done by grafting a limited exception onto the RPS objective where a development meets the NPSUD because it adds significantly to development capacity and contributes to a well-functioning urban environment. Therefore, read in the light of the NPSUD, the objective in the RPS should now be read as meaning avoid, except if otherwise provided for in the NPSUD. This allows a decision maker to consider whether a particular plan change would add significantly to development capacity and a well-functioning urban environment on a case-by-case basis and granted on its merits, even if it's unanticipated by MAP A. That is just as Policy 8 intends. It is appropriate for the NPSUD and the RPS to be read together in this way, as the NPSUD requires local authorities to give effect to it as soon as practicable. In the absence of any amendments as yet to the RPS to give effect to Policy 8, this interpretation would allow the Selwyn District Council in this process to give effect to the policy. We emphasise that this will not open the floodgates to all out of sequence or unanticipated development within the district. Not all proposals will meet the criteria of Policy 8, noting that there are a number of very specific factors to demonstrate whether something's a well-functioning urban environment criteria. This will necessarily involve hearing evidence on that topic from applicants and individual submitters and a proper merits assessment by you as decision makers. The urban growth overlay has been based on the projected infrastructure boundary contained in MAP A of the RPS. As such, the submitters consider that the references in the urban growth chapter to the urban growth overlay will be contrary to the NPSUD in the same way as the RPS might be if not interpreted correctly to reconcile the inconsistency between the two documents. The submitters therefore seek specific relief to the urban growth overlay provisions in this chapter set out by Mr. Phillips. Now, just commenting on the counter arguments raised by other parties, a number of other parties, and particularly Environment Canterbury and the City Council, have lodged legal submissions that expressly reject our arguments with respect to the interpretation. And in response to those, we would simply like to emphasise we reject the assertion that PC1 to the RPS gives effect to the NPSUD in the way that has been asserted by those councils. PC1 was limited to include only the future development areas already identified through the Our Space process, which started in 2018 under a previous national policy statement. Submissions on PC1 seeking to have additional land included were considered not to be on the plan change and were therefore out of scope. This precluded any merit-based assessment of any other land beyond the already identified FDAs, with any reconciliation of MAP A effectively being deferred until the next review of the RPS scheduled to commence in 2024. PC1 at best, and as recognised in ECAN's own internal reports on the plan change, could only ever partly give effect to the MPSUD, and that part was not Policy 8. We do not suggest by any means that Policy 8 should be considered in isolation to the rest of the MPSUD. In fact, it is crucial to view the document as a whole, nor does our legal interpretation rely on Policy 8 of the MPSUD having any particular elevated significance over the other objectives and policies in the document. All other objectives and policies in the MPSUD will be relevant in the context of whether a particular plan change achieves the purpose of the MPSUD and to which it would be appropriate to apply the responsive planning framework to. For example, we consider it unlikely, if not impossible, that there would ever be a situation where a plan change meets the test in Policy 8 but is contrary or inconsistent with Objective 6 of the same document. We reject the notion that a hardline approach to urban growth may be warranted under the MPSUD. This is particularly so when the MPFE fact sheet on responsive planning explicitly states that a hard rural-urban boundary without the ability to consider change or movement of that boundary would not meet the requirements of the responsive planning policy. As such, there is an inconsistency or a tension between the RPS and the MPSUD which must be resolved in order to meet the requirement to give effect to both of these documents in section 75.3. Our interpretation above sets out the most appropriate way to reconcile this inconsistency in the way intended by the MPSUD, being the document that came later in time. Nowhere in the MPSUD does it require that responsive planning be undertaken in a manner that contemplates existing strategic planning, which is the argument we've heard from Council. It is not clear how or why the City Council would read this requirement into the MPSUD when the MPSUD is clearly trying to do the opposite. And just one further point, I don't know whether it's a question that has arisen already at this hearing this week, just to confirm that we agree with the advice of Adelaide Head that the RMA equates a proposed plan and a plan change as being the same, and therefore this proposed plan review process is a plan change to which Policy 8 would apply. We say the words plan change in Policy 8 would also encompass any submissions on a proposed plan, noting that that will be particularly relevant to those submitters who've sought rezonings. We consider that they are captured by the plain and ordinary meaning of plan change. Private plan changes in that they seek a change to the operative plan, council plan changes in that they seek a change to the operative plan, a proposed plan as part of a plan review, which this is, and submissions on that proposed plan process. We do not consider it relevant that technically a rezoning submission is seeking a change to a proposed plan and not an operative plan, because ultimately that submission point is a submission on a change to a proposed plan. To this effect, a full plan review is a plan change in terms of Policy 8, and therefore a submission on a proposed plan must also be considered a plan change as part of that process for the purposes of Policy 8.
Thank you very much for that. That's a very useful and concise summary of the legal position from your perspective. So thank you very much for that. We'll see if we have any questions on that before we hear from Mr. Phillips, if that's all right. And we have a predetermined order of questioning since some of us are on Zoom. So Andrew.
Thank you for the legal submission. Look, I think it traverses issues well, as with the different, I guess, conclusions in some of the others we received, but I think all of them have been reasonably clear, and it's just a matter of interpretation. So I don't have any questions. Thank you.
Thank you. Lindsay?
Yes, I agree. It is a concise view of your position. Obviously, there is contrary positions which you have traversed as well. I just had a couple of questions, and just in relation to your summary, at your paragraph 25, you say not all proposals will meet the criteria of Policy 8, noting there are a number of very specific factors to demonstrate under the well-functioning urban environment criteria. What would it be useful in a plan context to actually specify what those very specific factors might be?
I think it would be, and that's effectively Policy 1 of the MPSUD that sets out those factors. Mr. Phillips and I have just been through a series of plan changes for 2 very large residential rezonings in Lincoln and Rolleston, and constantly we've had to try to tie the evidence back to those matters which are listed in Policy 1, which talks about meeting the needs of different households, enabling Māori to express their cultural traditions, having variety of sites, having one issue that's come up very to the fore in the plan change hearings we've been involved in is the accessibility issue. And that's not only cars, it's cycles, pedestrians, etc., and have those links between housing, jobs, open spaces, community, etc. That criteria on its own, I think, occupied about 1/3 of our last 2 plan change hearings. The evidence on that. Greenhouse gas emissions, we had to call specific evidence on that, which isn't something I've had to do at previous hearings. And the effects on climate change, we had to call specific evidence on that. So we kept coming back to Policy 1 as a bit of a touchstone, didn't we, Jeremy, in terms of all our evidence having to demonstrate that it was meeting those criteria in Policy 1 for what decision makers are looking for when they're deciding whether something meets the definition of well-functioning urban environment. Now, that's not an exhaustive list by any chance, but it certainly did give us a pointer to how we went about framing the evidence for those hearings.
And just leading on from that, in terms of your primary relief referencing MPSUD in Policy 3 in particular, MPSUD is quite it's a reasonably lengthy document.
Yes.
And just in terms of decision maker and looking at that, it's very broad. It doesn't really, it obviously has some objectives which need to be given effect to, but it is a very blunt instrument. You don't necessarily find in planning policy reference to the entirety of another higher order document.
Yeah.
Which is a point which was raised yesterday, because certainly the Regional Council are of the view that the whole Plan Change 1 process did give effect to the MPSUD, and therefore, my reading of it doesn't advance us all that much, because you've still got to go back and trawl through the document itself, the MPSUD, in order to be able to make some determination on the matter before us. Do you have any comment on that?
I agree with that. It's a question of how you would draft it. To be blunt about it, the words except if otherwise provided for in the MPSUD were just to give a pointer to there was an exception, and we weren't just starting with a bold avoid policy and then I was going to have a battle with ECAN and City Council on every application as to what that meant. So it's really a pointer to avoid doesn't mean avoid, and trying to do it in a way that doesn't mean that we have to put the whole MPSUD in. I don't know if there is a way of sort of summarising it. Mr. Phillips might be able to comment on that.
Yeah, I would appreciate that when we come to Mr. Phillips, but a suggestion was raised yesterday, and I can't recall who it was, but you look at Policy 3 as being, if you like, the real driver of determining where urban growth should occur within the Greater Christchurch area. And you could say, well, avoid it, because you've had all these strategic planning processes which are defined, the areas which have been identified, and instead of throwing that particular baby out with the bathwater because you've now got Policy 8, you could look at Policy 3 and say, well, avoid it, but in these circumstances, you might be able to take into account Policy 8 of the MPSUD. Would that be a framework which could be looked at? Or
yeah, that might get us there. I mean, Policy 8's already, as I said before, you've got to meet significant development capacity and well-functioning urban environments, which are, we've got pointers to what well-functioning urban environments are. We don't yet have any criteria as to what add significantly to development capacity means. But there's certainly something we could do to the wording to make it a bit clearer about where it's heading, rather than just say holus bolus adopt.
Yeah, I think part of the reason we're here today and we have contrary views is that there are different interpretations about what the NPSUD actually does.
Yeah.
The whole term well-functioning urban environments might mean different things to different people. And obviously we're looking at provisions which are going to be used going forward to look at particular development scenarios and whether they actually do achieve a well-functioning urban environment. And without any more specific guidance, it's not going to advance us all that further. Is that what's the view on that?
That's fair. I mean, as a lawyer, I'd take a word like well-functioning urban environments, and I would look at the policy 1, which sets out what it is at a minimum, but that is only a minimum. So I think it would be helpful for parties to have guidance.
Okay. All right. My next question was in your para 29.5, and you say nowhere in the NPSUD does it require the responsive planning be undertaken in a manner that complements existing strategic planning. So
probably what I should explain there, because I haven't put a footnote, that is a lift from one of the legal submissions, I think from the City Council. So sorry, I haven't footnoted where that quote comes from. So just to explain, that is shorthand for the City Council saying that it has to complement it in a way that meets MAP A.
So is the fact that regardless about the NPSUD, Canterbury region post-earthquakes has been doing a lot of strategic planning about where growth should go. So is policy 8 basically mean that strategic planning has no value or limited value, or only, it seems to me there's been a lot of work that's gone on to determine both MAP A and the provisions, and they're reflected in the plan as we have it now.
Yes.
So are those strategic planning processes of no value anymore because we have a get out of jail free card with policy 8 of the NPSUD?
Absolutely not. And this question was front and centre at the last 2 plan changes, and particularly at the one we did last week in Lincoln. So we still have policy that sits behind MAP A. And all the reasons why the MAP A line was drawn where the MAP A line was drawn. So it's only the line itself as an immovable boundary that's the problem, and the avoid word, but all of the thinking that went behind the reasons why a line was drawn there, and all that, the effects and the issues that were looked at, and the policy that went behind MAP A are still as relevant as they ever were. What is not relevant is saying the line's there and it can't be somewhere else.
Okay.
All the reasons for putting a line somewhere are relevant still, and as relevant as they ever were.
So
there's some strategic planning documents that are at district level as well. There's a Rolleston structure plan, there's a Lincoln structure plan. So there is lots of planning that has been going on, and all of those are still relevant.
So the problem is with the line, or where the line is, not that there is a line.
Yes.
Okay. Thank you. I'm sure we'll hear more about this from others as well. Thank you, Chair.
Yeah. Malcolm?
Yeah, thank you, Ms. Appleyard. I do appreciate your summary. It has certainly laid things out on a structure that makes it easier for me to contemplate. I have no further questions.
Thank you.
Thank you. Nicole?
I echo the same comments that have already been made. It's quite an issue that we'll have to deliberate on, but thank you for your explanations.
Deborah?
I just have one, and it's just in regard to the hierarchy of the planning documents and the timing. Just for clarification, what came first or what came last, the MP National Policy Statement or Plan Change 1 to the RPS, the latest one? What was first?
We filed a timeline with some of our earlier submissions, which I don't know if I've bought a copy of, so I'm going off the top of my head now. So our space came first, which was the process that established where the future development areas were to be. They were promulgated at the time of the previous version of the MPS UDC. And then the MPS, I'm just going off the top of my head there, the MPS UD, the latest came in, and then Plan Change 1 to the RPS caught up effectively to put the future development areas that had come out of our space into the RPS. So they effectively came last, but they were implementing a process in a document that had come first. So effectively what we say is that by the time PC1 caught up, we had the MPS UD, and PC1 only partially gives effect to the MPS UD.
Okay, thank you.
There is a timeline attached to our submissions on strategic directions. It is quite complicated.
Mark?
Thank you. No, great summary.
Raymond?
No, thank you.
Yvette?
No, thank you.
Gary?
Yes, thank you. Just one question. Policy 3, UGP 3.
Sorry, your policy 3.
Yeah, sorry. Yeah, that's where there was some discussion that you had about the word avoid, and to not put it unkindly, I think you said you wanted to
avoid the word avoid.
Hide the word avoid.
Put the word avoid.
Yeah, I was just wondering from a legal point of view how important it is where that word avoid is located.
Not at all. In fact, I'd be happy if it wasn't there. I'd be happy if it just said the zoning of land shall be, as provided for the MPS UD. But I was trying not to do too much violence to the.
So it's just that one other submitter suggested avoid at the front and then unless. Does it make a difference from a legal point of view?
Absolutely not.
It doesn't.
Yeah.
Okay.
Yeah.
All right. Thank you.
So we've been mulling over how we do exactly what you have said we need to do, which is to give effect to both the MPS and the RPS. And we take on board and agree, well, I certainly agree with your submission that we should firstly attempt to reconcile those provisions rather than going for the nuclear option, which is just to get rid of the urban growth overlay altogether, because that would just rip the guts out of this chapter. And so we've been, and in particular, I've been thinking about how we might go about that. And so I think it's only fair that I put to you so you can respond just where my thoughts are. And yesterday posed some questions to other submitters about policy UGP3, which other commissioners have already discussed this morning. And one option that has occurred to me is to leave it as it is, but to add on to the end of it the words unless the rezoning. And then I've been thinking about, well, what would the unless need to do? It would need to address the MPS UD and also encapsulate all the other requirements that the district plan and the MPS would require a well-designed plan change to achieve, which I think is what you've been saying you've been doing in evidence.
Yeah.
So my latest thoughts on that, and this is pretty much an evolving issue and certainly nothing set in stone, but I'd appreciate your response, is that there would be two limbs to the unless. And the first one would be that the rezoning would need to add significantly to development capacity, trying to tick the MPS box. And then the second limb would simply be that it would need to give effect to objective UGO1, which is the existing objective in the urban growth chapter that lists a whole lot of things that in my interpretation is what Selwyn thinks a well-functioning urban environment needs to achieve.
I'd have absolutely no issue with that. I think that would be very sensible. And then probably just need to make sure that UGO1 has got everything in it, and in particular things like the climate change greenhouse gases, anything that's in the urban, make sure that the list is complete, that everything in the UDS and anything, and that's a minimum, and anything else that Selwyn regards as important is in that list. In theory, I think that would be a very sensible outcome.
Yeah, and what I thought that might be useful was that by referring to UG01, we then don't need to parrot everything that's in the subsequent UG policies, because they then stand on their face, because they're all designed to give effect to UG01 anyway.
Yeah, that's I think that would be very sensible. So so that the UG01 would take the minimum that the UDS requires and anything else that Selwyn specifically regards as in its district contributing to a well-functioning urban environment. And just looking at it, it actually probably is better than it's probably better than the NPSUD because it's more specific to the district.
Yeah, and my thought was in that way, I'm always keen to add value to these higher order statutory documents rather than just parroting them, and I think that's what UG01 does.
Yeah, it doesn't mention climate change, greenhouse gas emissions, so there might just need to be another couple added in there to meet that minimum in policy 1. But that's probably just a pretty basic drafting exercise to make sure that the minimum requirements are met. Yeah. And just practically, we did find policy very helpful, didn't we, in preparing the evidence, just going through, particularly the transport one about you need to have connectivity and you need to have accessibility in terms of cycling, pedestrian and cars. It was all very, very clear. And if it's as clear as policy 1 was in merging the two, I think that would be a really good outcome, and it would certainly focus plan changes and make the job of applicants easier and decision makers easier as to the type of developments we're looking for that are going to fall within the unless. And then the other thing, obviously, you've got to add significantly to development capacity. The RPS will soon tell us what the criteria is, although there is some criteria in one of the MPS documents does have a pointer as to what they're looking for.
But in the meantime, prior to the RPS having those criteria, and I think we heard yesterday that we won't be notified of 2024, and one of my colleagues says, well, that means they probably won't be operative until about 2026.
Well, and that's what we're hearing at these hearings. I mean, we're basically hearing the City Council and ECAN saying you've got to wait till ECAN's develop the criteria to tell you whether significant development capacity or not, and we're saying, come on, it's 2,000 sections at Lincoln.
Yeah,
that's significant on evidence and well-functioning urban environment. We've been going back to policy 1 and going through each of those things, but if this plan had a policy that was equally as descriptive of the things that decision makers are looking for, I think that would be very helpful to applicants.
So prior to the RPS becoming operative with these criteria, just be up to each applicant to mount an evidential basis for
and
development capacity.
Yeah, so the two that we've done, Rolleston and Lincoln, Lincoln was about 2,000 sections. Rolleston was about the same, wasn't it? There's one at West Melton that's about 140. So I think that decision is probably going to help on whether that falls into that category. Whereas the two plan changes we had, I don't think we have a problem getting over that threshold, but we may have some problems around things like accessibility and some of the other criteria.
Yeah.
But it's being done evidentially at the moment, and I think we'll just keep muddling on, doing it evidentially until the RPS catches up.
And so in terms of the question I put to you about an amendment to UGP3, that's only my personal view. We haven't discussed this as a panel, and other commissioners may have quite different views. And we've yet to hear all of the evidence in this hearing, but I was just interested in your response to that thought.
Oh, it's helpful, thank you.
As Judge David Shepherd used to say, it's giving applicants a fair crack of the whip so they get to know what we're thinking rather than have surprises spring out. So that's all. All right, thanks very much for that. So we can hear from Mr. Phillips now.
Good morning, sir. I'll take you through my summary. My name is Jeremy Phillips. I'm a senior planner and a director practicing with Novo Group Limited in Christchurch. I have particular experience in urban land use development planning in Greater Christchurch and have a clear understanding of how current district plan provisions are applied and the implications on those contemplating development activities. Except to the extent that provisions associated with the urban growth overlay may preclude future urban growth that may otherwise be appropriate when assessed in accordance with the NPSUD and Policy 8 especially, the urban growth chapter as proposed by the officer is generally supported for the reasons set out in the officer's report. To the extent that I consider further amendments are necessary, I summarise the main points of my evidence in chief below. Firstly, the overlay. To the extent that the overlay signals a preference for growth in one location over another without a robust evidential basis, I consider this as speculative, and it may have unintended consequences for those with interests in land subject to the overlay, adjacent land, and/or other land that may be better suited to future urbanisation in terms of their land use choices or planning. However, setting aside my concerns with the positive identification of land that is potentially suitable for growth with an overlay, my evidence is more concerned with the potential for the urban growth chapter to preclude or undermine proposals for growth that are unanticipated or out of sequence, but which warrant responsive planning and decision making, accounting for the NPSUD and Policy 8 in particular. My evidence concludes that there is generally a high degree of alignment between the provisions in the NPSUD, the CRPS, and the proposed district plan as to the when, what, and how for urban growth. To the extent that there is tension as to the where, I consider that the NPSUD requires, in limited circumstances, more responsive planning than the CRPS and the proposed urban growth provisions currently provide for. I note that the planning evidence for a number of other submitters draws similar conclusions as to the inflexibility of the CRPS and the proposed urban growth chapter and the need for a more flexible or responsive framework. Whilst I agree that the avoidance directives within the CRPS and the district plan should remain as the default framework for determining urban growth proposals, Policy 8 of the NPSUD allows for certain plan changes to be considered outside of these norms, where they are unanticipated or out of sequence, and their significance warrants a more expedient response. Plan changes under this policy will remain the exception rather than the norm, noting the requirements to be significant, well connected along transport corridors, and to contribute to well-functioning urban environments. Such proposals would also still be assessed on their merits in terms of their appropriateness, accounting for all relevant NPSUD, CRPS, and district plan provisions, including those relating to urban growth. In light of this, and consistent with my evidence on the strategic directions chapter, my evidence acknowledges that the overlay and the associated provisions in the proposed plan could be retained, provided that there is an explicit exemption for proposals that meet Policy 8 of the NPSUD. And attachment 1 to my summary details relief to that effect. I've had particular regard to the evidence of Ms. Phillips for the Canterbury Regional Council, noting her analysis of the NPSUD and the CRPS and the extent to which the urban growth chapter gives effect to these statutory planning documents. Notably, I agree with Ms. Phillips that until such time that significance criteria are inserted into the CRPS, decision makers assessing plan changes will need to consider the implications of this national direction alongside the policies contained in Chapter 6 of the RPS. In my view, this balancing act can also apply to plan changes that meet the significance criteria once they are set out within the RPS. I note that Ms. Phillips' summary of the NPSUD Objective 6 emphasises the requirement for local authority decisions on urban development to be integrated with infrastructure planning and funding decisions and strategic over the medium and the long term, but omits the requirement to also be responsive, particularly in relation to proposals that would supply significant development capacity. I consider this requirement as important in the context of addressing submissions and evidence seeking a more responsive urban growth chapter. I share Ms. Phillips' view that Chapter 6 provides a strategic policy framework for growth, which is significant in terms of informing the approach taken by the proposed plan and Selwyn District Council's approach to managing and providing for growth more generally, and that Policy 8 of the NPSUD is not a standalone clause. It contributes to a wider framework for encouraging development in appropriate locations, and the responsive planning obligations on local authorities are intended to complement other obligations in the NPSUD. And lastly, that the process in Clause 3.8 of the NPSUD does not automatically negate the urban growth framework contained in the RPS and the obligation to give effect to it. Ultimately, I consider there is little difference between Ms. Phillips and I as to our views on the NPSUD and the RPS provisions concerning urban growth and the role of the RPS, housing capacity analyses, and other strategic planning initiatives to direct urban growth in the default. However, our opinions diverge on the appropriateness of the proposed plan, providing an exemption from that default where the NPSUD and Policy 8 is engaged, which allows responsive decisions on eligible plan changes. In my view, and with reference to the evidence of Mr. Copeland, and that's from the Strategic Directions chapter, I consider such an exemption as the most appropriate option, accounting for the associated benefits, costs, efficiency and effectiveness relative to a highly restrictive framework, and the risks of having provisions that are not responsive to demand and needs for housing and business land. Accordingly, my conclusions have not changed, accounting for the evidence of Ms. Phillips. In terms of the two minor matters, in para 12, I note the definition of housing bottom lines should not, in my view, be tied to household numbers that are identified in the RPS, on the basis that this may inhibit a more responsive approach where more recent numbers in a publicly available HBA are available, but are yet to be formally incorporated through amendments to the RPS. In terms of UGP 11, I have no concerns with the intent or the substance of that policy or the associated refinements that have been sought in the evidence on behalf of other submitters with a specific interest in that policy. However, I consider it's important that the wording of the provision does not inadvertently seek to avoid any or adverse effects on the activities that are described in the subclauses of the policy. I also consider the extent to which effects on the activities described in those subclauses are to be managed needs to be distinguished, noting their corresponding direction in the RPS in respect of strategic and other infrastructure. And attachment 1 to my summary details those amendments. Thank you.
Excellent. Thank you very much for that concise summary. I'll see if we have questions arising from that and also from your fuller brief of evidence. Andrew.
Thank you, Mr. Chair. Thank you for your evidence, Mr. Phillips. I've got a few questions. One sort of a general one, really. It's not specifically referenced to a paragraph in your evidence, but discussion on Policy 8 evidence yesterday talked about the ways of giving effect to it and how it didn't necessarily have to be a plan change. It could be other ways that a council could respond. And I'm interested in your thoughts on that. For instance, altering an 30-year infrastructure strategy or something else. Do you have a view on that, or is it, do you think in your view it's more tied to, I guess, the district plan and plan changes?
I think in response to that, Policy 8 requires responsiveness to plan changes specifically in terms of the wording, but I think the fact that that provision in effect opens the door, in my view, to significant proposals presenting themselves and that they may not have otherwise been accounted for in terms of infrastructure planning, and probably the wider messages within the NPSUD about being responsive and meeting demands. I think that would signal to councils that they perhaps need to be, again, more responsive and adaptable to change that may not have otherwise, in a way that may not reflect how they've done it in the past, I guess, with a more planned and rigid planning framework that says growth shall only occur here, here and here. And they may be limited in the extent to which they can do that in terms of how easily you can add wastewater capacity or water capacity or roading capacity. But I think being mindful of the need to be responsive is certainly a message that comes through in Policy 8 in terms of plan changes, but more widely in the NPSUD, and that would naturally follow through to infrastructure planning.
Right, okay, thank you. So you've covered in your initial evidence, I think in 13th November, but also 30th, but the housing bottom lines change that you've addressed in paragraph 30, 31, 32 in your earlier evidence. And then you've got a recommended change there in paragraph 32. And you've sought to delete reference to the RPS in relation to the minimum number of households. And you have a rationale for why you're proposing that. My question is it helpful, though, to refer instead to an HBA or some other document to help us understand what is demand and where did demand come from and how is it calculated or ascertained?
The short answer would be yes. I think the intent of that change was that that definition wasn't tied to something that may take a period of time to actually appear in the RPS, and then finding that hamstrings the use or the application of that definition. I think if you referenced a publicly available HBA, that would achieve the same intent.
Thank you. And then I've got two more questions, and this is in relation to your evidence that was dated 30th of November. And I'm looking at page 7, and in particular, the changes to Policy 13 in red and underlined, and this would also be applied to 15 because it's the same change. So it's the addition that you've added in, except that clauses 1 to 3 should not apply to new areas that are otherwise provided for in NPSUD. And I'm interested in why would 1 not be relevant and why would 2 not be relevant. So 1 is the extensions of system meeting housing bottom lines. And so I'm assuming that if you're proposing a plan change, that it would assist in meeting those bottom lines. So I'm trying to work out why would that not be relevant. And I'm also assuming that it would be in response to demand and potentially then should also be identified or have support through those housing capacity assessment. So again, why would 2 not be relevant?
I think they're fair points and fair questions. I think the concern probably born out of experience with recent plan changes is the question over the veracity of the numbers that are contained within those assessments, and where evidence might indicate that they are underestimating demand or overestimating supply, and you end up in a situation where an argument's presented that a development's not delivering significant capacity or it's not warranted under the NPSUD because those numbers are otherwise met. So I think I wouldn't necessarily have a concern with the references to those provisions. I think it's the key is that you're not tied to those. I guess that there's an ability to look beyond them. I mean, the whole premise, I think, of my evidence and the concern with the wording at the moment is where it closes the door on a discussion around the appropriateness of proposals that might deliver significant development capacity, both in terms of the capacity they're offering and the merits in terms of their contribution to a well-functioning environment and all the other provisions. So I think if there were reference to those, I think as long as that proverbial door is left open, then that would be fine in terms of signalling a matter that might inform that consideration.
And certainly I can see why you'd want to exclude clause 3, which is, I guess, the key focus.
Yeah.
Okay. All right. Thank you. No further questions.
Lindsay?
I put to the question to Ms. Appleyard, and I think she invited you to comment on it as well, about the appropriateness of including all of a higher order document within a policy, in this case the NPSUD. And I think I expressed my reservations that it was potentially too broad and didn't really give, at a policy level, at a district plan policy level, sufficient guidance to decision makers. Do you have any view on that? You don't often see, reference to higher order documents too often in district plans.
Yes, fair point. And I mean, I was furiously writing notes in the course of that questioning. I mean, I think in my view, the well-functioning urban environment definition can effectively provide a checklist in terms of other provisions within the urban growth chapter addressing those, and if not, are there gaps? I think in response to the chair's question to Ms. Appleyard about possible alternatives to UGP3, I wondered whether there could be merit in a definition of a well-functioning urban environment appearing that then points specifically to policy 1. That might be another means of getting there. I think the key message is, I think the requirements in policy 1 of the NPSUD are fundamental to proposals seeking to be advanced under policy 8 and operate outside of that avoid framework that we have. Therefore, those provisions in policy 1 need to be reflected either within the plan specifically or by reference.
Yeah, I think the chair said not necessarily policy 1, but alignment with the objective UGO1. I think was the chair's option that he floated for comment about whether that was a way of potentially getting around this hugely vexed issue, to be frank, with policy 8 going over the top of the RPS.
Yes, I accept that. I think if objective 1 adequately covers the matters referenced in policy 1 of the NPSUD, then there wouldn't be a need for that separate reference. It was more that if there was a concern about trying to bolt on effectively additional provisions, or that there's a nuance, I guess, in terms of the message in policy 1 of the NPSUD that might not be reflected in the drafting of the proposed plan. Again, whether a definition that references that policy directly is another way of ensuring it's covered. I think the key point is that you've got to be satisfied that policy 1 is covered somewhere.
Yeah, and in terms of the strategic planning processes which have gone before, I think you've got general alignment with the philosophy in behind them. It's just a matter of the implementation of that philosophy within both the RPS and the proposed plan provisions. Would that be a fair interpretation of your view?
Absolutely. I think the key, and again, born out of experience with these other plan changes and going through what the purpose of the avoid directive in the RPS is about. That's part of a broader framework that's trying to achieve a number of different things relating to infrastructure, consolidated urban form, transportation, connectivity, supports of commercial centres. So there's a whole layer of matters that contribute to a well-functioning urban environment, and of which the avoid to date has been a pretty blunt means of achieving that outcome. I think I'm saying that proposals would still need to demonstrate how they achieve that broader framework, but they need the flexibility to do that, and we don't currently have that with an avoid framework. So that flexibility needs to be provided, and in my view, that's what the MPSUD Policy 8 is seeking to provide for.
Okay, and just leading on from that, on the assumption that there is an urban growth overlay, would it be a fair proposition that if there is a proposal which is unanticipated and outside of those particular area, that the policy bar should be higher in terms of the test, the merits-based test that would be applied to any rezoning?
I think that bar would naturally be higher in terms of satisfying the requirements in Policy 8 around significance and contribution to well-functioning urban environment and integration with infrastructure where that might not be planned in those locations. I don't know whether the merits necessarily need to be elevated, because I think ultimately those merits considerations are universal across the district in terms of good urban form and good urban design and transport connectivity and greenhouse gas emissions. And so I think proposals will, wherever they are, will naturally be subject to those considerations. I think the overlay, and I mean, I talked about it being speculative. I think they reflect thinking to date about where growth may or may not be appropriate, and there's sort of a guide, but they're still going to need the same analysis when it comes to a plan change to demonstrate that they are the most appropriate, or rezoning that land is the most appropriate option.
But you're going to have a greater leg up in terms of achieving well-functioning urban environments if it's already specified as being an area appropriate for development.
I'd accept that, because I think the fact that they've probably been identified in an overlay or in a process to date probably indicates that whether it's cursory or a more detailed looks, there's been some examination of how that fits within the framework that we have to date. So I think I would accept that. I just don't think it's conclusive. It would be conclusive.
You mentioned the word speculative, and this is going back to your summary statement today, your para 5. To the extent that the overlay signals a preference for growth in one location over another without a robust evidential basis, I consider this as speculative and has unintended consequences. Well, is it speculative if there's been a large amount of strategic planning work that has been done before, which specifies a line where urban growth should occur?
Yeah, speculative may be a bit harsh. I think what my reading of that overlay is that there's been varying levels of analysis, and that analysis hasn't gone so far as to conclude that rezoning is appropriate. And I think that's the concern that I have, that if that's signalling at present where growth should occur and other areas beyond that overlay shouldn't occur, that's the primary concern. But I think I'm signalling that I haven't seen evidence that it's conclusive that those areas most appropriately rezoned.
But to get this far, they must have gone through a fairly robust process.
Well,
Something of a robust process in terms of the
well,
whole Section 32 process that's been going on with the proposed plan to date.
well, I mean, my reading of Mr. Beard's report was that that level of analysis hasn't occurred to date, not to the point of concluding that the land should be rezoned. And I think in terms of the responses to requests, I think it was from Kaingaroa seeking a future urban zoning, noting that that's a matter that would need to be determined through further evidence and analysis on the actual rezoning hearings, that the evidence base isn't at that point at this point in time.
Okay. Maybe speculative, if I can use this word, but your paragraph 10.1 of your summary mentions the significance criteria, which will need to be developed by the regional council, and what they might mean. Presumably, it'd be your position that the significance criteria would be more or less aligned with potentially what's in policy 1 of NPSUD. I don't know if you've thought about that at all, but what would these significance criteria mean, and what would they actually mean in practice to what the district plan provisions actually provide?
I think the significance criteria, I think it's going to be a hard exercise to set it, because my reading of the NPSUD is that it's more than just policy 1 that provides direction around the capacity that needs to be provided. So, for example, you've got competitive markets in objective 2. You've got demand related considerations in objective. You've got the need for competitive land and development markets in objective 2. You've got considerations around high demand and enabling more people to live in those locations in objective 3. You've got the needs and the varying needs of households in policy 1. You've got sufficient capacity to meet demands in policy 2, and then policy 3 you've got considerations around heights and density of urban forms. So I think there's a number of factors that need to be accounted for when, and then obviously considering differences within the wider urban environment. For example, is demands in Rolleston versus West Melton versus Lincoln versus areas of Waimakariri district or Christchurch City. So those significance criteria would need to reflect those. So
okay. And finally, you had a discussion with Commissioner Willis about the housing bottom lines definition, and we had quite a bit of evidence yesterday that the numbers were a problem, particularly the 15 households per hectare, and I think that's policy P13, where they actually manifest themselves. So your recommendation would not be to have any metric involved in terms of the objectives and policies in relation to housing bottom lines. It's just a sufficient capacity, or at least sufficient capacity, needs to be provided, as opposed to putting a metric on it.
I think as long as, probably in response to my response to Mr. Wallace was, I think there needs to be caution that if there's reference to those numbers, it needs to allow for testing of those over time in the event that evidence shows that they've undercooked or overcooked the given numbers. So I don't have a problem with referencing those figures, providing the scope to consider new evidence rather than being fixed. Again, it's about being responsive and I guess providing sufficient flexibility to be responsive.
Okay, thank you, Mr. Phillips.
Malcolm?
No questions. Thank you.
Thank you, Nicole.
No questions from me either. Thank you.
Good. Deborah?
Yes, I've got one question, and I guess it's a query around the emphasis of Selwyn developing a criteria that best suits Selwyn to manage the avoid unless scenario. And I want to understand, given that when we are within the Greater Christchurch Urban Development Strategy area, we do have partners And I just wondered, if you actually take that planning mechanism higher up, probably through the RPS, should we actually be taking note, given that partnership arrangement, of what our neighbours are saying about our growth over their growth?
Yes, I think you should. I think in saying that, the NPSUD provides us strong message or objectives and policies, in my view, around differing needs and demands and markets, and the fact that there will be those needs and demands and markets will differ between Selwyn and Christchurch and Waimakariri, and also within those authority areas and parts of the urban environment. I think that's where the challenge is, in terms of how do you give effect to that direction, whilst at the same time being cognizant of that wider relationship and that wider planning. And I think that's where, again, having a framework that reflects the regional policy statement and that wider regional view is the default position. It's, again, coming back to providing sufficient flexibility to be responsive for proposals that might meet the individual requirements within different parts of the district, and can be shown to be warranted. So I think the short answer is yes. I think you've got to be mindful of those wider relationships, but you've still got to account for local needs.
Mark?
Thank you.
Thank you. I really got one question on your proposed amendment to UGP 11. In your first clause, you talk, this is in the context of when zoning land, avoid significant and remediate or mitigate other. I'm not quite sure the use of the word remediate when you're zoning land, remediate reverse sensitivity. I'm not quite sure whether remediate's quite the word that you intended. It doesn't. Remediate normally in my context talks about sort of fixing an existing problem. But when you're zoning land, there shouldn't be an existing problem you should be fixing. So I'm not quite sure whether remediate is either superfluous or redundant in that context. Avoid or mitigate would seem to be the words. I'm not quite sure what you meant by remediate.
Yeah, that's a fair question. Off the top of my head, I'm struggling to think of how of an example where you might do that. I think it's sort of parlance of using avoid, remediate, or mitigate, and that's probably the basis for it.
But if it just simply said avoid or
mitigate,
avoid significant or otherwise mitigate, would have seemed to achieve that goal without that word.
Yeah, without being able to think of an example of remediation, I'd accept that.
Thank you.
Raymond?
No, thank you.
Yvette?
No, thank you.
Gary? And Ms. Phillips, no further questions from me, but thank you very much for your evidence. Helpful. Right, we're running a little bit behind schedule, and our next submitter is Kainga Ora, who are going to join us by Zoom, hopefully. Oh, yeah, you can move back. Thanks. Okay. So do you know if they're there or not? So Kāinga Ora representatives, can you please turn on your microphones and cameras if you're able to hear this? Yes, good morning, Mr. Roberts.
Good morning.
And are you going to be joined by anyone this morning?
I hope so. Lauren should be here, and representatives from Kāinga Ora too. Shall I give them a call?
That might be helpful, thank you.
She's struggling to get into the meeting.
I'm here.
Ah,
Right, good morning and welcome.
Good morning.
Morning.
My apologies for that slight technical hitch. I'm not sure why my other screen tells me the meeting host wouldn't let me in, but I'm here now.
All right, well, thanks very much. Over to you.
Good morning. So Kāinga Ora's position is that the proposed plan must be prepared obviously in accordance with both the national planning standards and give effect to the NPSUD. And I'm aware that you've been addressed at length in the last day and certainly this morning on the implications of the relationship between the proposed plan and the NPSUD. Kāinga Ora's position, I guess, is a little more constrained than some of the other submitters, to the extent that its interests are concerned primarily with the existing urban environments and areas that are already zoned and the implications of these provisions for those areas. And so it's Kāinga Ora's position, and as set out in my submissions, that the urban growth objectives are critical to this plan, and certainly the evidence and submissions that you've heard over the last few days give credence, I think, to that in terms of how important it is to the provision of well-functioning urban environments, and particularly matters of capacity are for this district. And for that reason, it has been Kāinga Ora's submission and remains their position that the urban growth objectives should be moved into the strategic directions chapter to reflect their critical role. Now, we've already addressed you in relation to that in terms of the evidence and submissions that were provided in the strategic directions hearing. You had quite some discussion with Mr. Roberts in relation to whether it should be all of the objectives and policies that were moved in, and he has amended his position and determined in his evidence that it should only be the objectives, and he's provided those in his evidence. So I'll let him speak to you in relation to that matter. In terms of those objectives, so looking at objective 1, Kainga agree with the officer's change to reflect that amenity in urban environments will change over time. And you'll recall that in the strategic directions hearing, we talked about that again, about this issue of ensuring that the plan was forward focusing and not necessarily looking always to restoring the position or maintaining the position of the past. There is, however, one remaining issue with that objective, which is the issue about effects on important infrastructure. It's Kainga Ora's position that that has the potential to be too constraining, recognising that we do have a national policy statement on urban development that is looking probably, I think it would be fair to say, more expensively about providing for development capacity and for the opportunity for development. Kainga Ora considers that the current proposed wording of that objective would be enhanced by the use of the term significantly affecting important infrastructure. And that again is in Mr. Roberts' evidence. With respect to policy 8, there is a reference there to all urban growth being constrained within the 50 dB LDN airport noise contour. Again, Kainga Ora's position is that that has the potential to be too restrictive and constraining on urban development. There are non-noise sensitive activities that come within the definition of formal urban growth that may be able to be enabled within those airport noise contours. And so accordingly, we seek some amendment around that to provide for that opportunity. And of course, in an objective and policy framework, we're not suggesting that that opportunity would be taken up or it should be taken up, but that the policy framework provides that opportunity to ensure that we are not unduly constraining development opportunity from occurring. In a similar vein, policy 9 also, there is a change proposed to that to protect not only highly productive land, but also land that adjoins highly productive land. And again, we say that that casts the net too wide. And I think, you know, again, coming back to, and this will be a consistent theme, I think, for you, coming back to what the NPSUD is looking to do. Obviously, what, you know, a well-functioning urban environment includes a well-functioning market that works and creates a competitive environment. It's part of what a well-functioning urban environment in terms of the NPS is. And if the market is too constrained by either, maybe one might say the regional policy statement, or by the objectives and policies of this plan itself, then it is hard to see how that will give effect to what the NPS is endeavouring to achieve. Policy 12, again, same vein. Here, Kainga Ora seeks an amendment to acknowledge that public transport may not always be planned ahead of development. It often follows. And if the policy requires that to be either in place or planned before development can be contemplated, then that is a barrier, a potential barrier to development that we say doesn't need to be there. Policy 13, I've heard the discussion in relation to that. Kainga Ora has similar concerns about the reference to housing bottom lines, again on the basis that that may prove to be too restrictive of a position to hold, and that using those which are a minimum has the potential to constrain the policy environment from giving effect to the NPSUD, which we say requires a much more expensive approach to be contemplated. So those are the matters that are left in contention. I thought I might say that I don't always agree with Ms. Appleyard. We're often on opposite sides of things, but I have listened to her submissions and her answers to questions this morning, and would have to say that I wholeheartedly agreed with the matters that she put to you and her interpretation of the relationship between the regional policy statement and the proposed district plan. So I leave that with you for what it's worth. So that's a very brief and quick run through of the submissions and the Kainga Ora position. Very happy to answer any questions or to hand over to Mr. Roberts and have him provide you with a short summary of his evidence.
Yeah, that's a very helpful overview, particularly highlighting the provisions that you still wish to draw our attention to. So in that regard, would it be acceptable if we hear from Mr. Roberts and then just pose questions to Kaingaroa generally?
Yes, absolutely.
An interesting point regarding the weight we should give to your legal submissions when you do agree with Ms. Appleyard, which is probably quite a rare thing. So thank you.
It is somewhat rare.
Thank you, everyone. I'm Nick Roberts. Just want to quickly take you through some highlights of my evidence. Firstly, in terms of the strategic directions hearing, I've prepared a tracked version of the strategic direction provisions to include the urban growth objectives. Having considered those matters in detail, I agree that the policies of the urban growth chapter contain a level of detail that may not be appropriate for the strategic directions section of the plan. So on that basis, my amendments really focused on the policies. So the three proposed urban form and development objectives have been merged with the three proposed urban growth objectives to create 4 new strategic objectives. And the proposed urban growth policies remain in the urban growth chapter. The urban growth overlay is another matter that will be discussed at a further hearing. So my reasoning for doing that is that it reduces the potential for conflict between the 2 sets of objectives in the district plan. It ensures that urban growth objectives are given primacy within the proposed district plan that their strategic nature requires and deserves. The planning standards state that the strategic objectives for the district must be located in the strategic directions heading of the plan, as I've set out in previous evidence. And the urban form and development chapter must be included in the strategic directions heading. As I've mentioned, contrary to my original proposition, I now consider that the policies of the urban growth chapter contain too much detail, and that would be inappropriate in the strategic directions section. And shifting the policies would create sort of orphan rules. So I'm happy to leave those in the urban growth chapter. So the consequence of this change is the urban growth chapter would now have policies without objectives. I agree that's imperfect, but in my view, it works still, particularly because the strategic objectives provide guidance to those policies anyway. And for clarity, a note could be added to the urban growth policies referring to the strategic directions chapter objectives. So I just wanted to talk through that first. I'll now talk through my evidence in respect of the key matters that Ms. Semple has raised. Firstly, in terms of objective 1, I note and support the reporting officer has partially given effect to the change to objective 1 as requested. This change means that the objective is now better aligned with the direction of the national policy statement with regard to recognising that amenity and urban environments change over time. Given that change, I'm comfortable with the inclusion of reference to amenity values and character within the objective. I therefore support the wording of UG01 as recommended in the Section 42A report. Turning now to Policy 8, the reporting officer has recommended amending Policy 8 to include reference to the 50 dBA LD air noise contours. I'm opposing this insertion as it has the potential to be unnecessarily constraining a potential future urban development that is not noise sensitive. And that's in line with RPS Policy 6354, which specifically talks about noise sensitive activities being constrained, but not non-noise sensitive activities. And I note noise sensitive activities are specifically defined in the plan. Turning now to Policy 9, I note the reporting officer recommends amending that policy to protect highly productive land and adjoining land and to improve clarity. I support the amendments to improve clarity and to protect highly productive land. That's again in line with the regional policy statement. However, I do not support the change to protect adjoining land. This has potential, in my view, to be unduly constraining of future development in areas outside of highly productive land that may be suitable for urban development. I therefore recommend deleting the words "and adjoining land" from Policy 9. In terms of Policy 10, I note and support the reporting officer's recommendation. This change means that the policy is now better aligned with the direction of the NPSUD with regard to recognising that amenity and urban environments changes over time. Given this change, I'm comfortable with the inclusion of the reference to amenity values and character within the policy. I therefore support that wording. In terms of policy 12, which includes reference to public transport services, I'm opposed to this insertion as I consider that public transport services do not necessarily need to be planned with certainty before rezoning of land. In fact, I don't know of any examples where one knows the exact services that are planned before rezoning. It always comes after. It is more important that the former development does not close off the future viability of providing public transport services. I therefore recommend deleting "and public transport services" from clause 1 of the section 42A version, noting that policy appropriately refers to the availability of existing and planned infrastructure in any case, and existing and planned infrastructure includes public transport infrastructure, but not services. And turning to policy 13, I'm opposed to the reporting officer's recommendation to retain clause 1 of that policy, which states that new residential growth should only occur if it assists in meeting the housing bottom lines. In my view, the bottom line should be considered as a minimum, not as an ultimate target beyond which development is constrained. I therefore recommend deleting that clause. And that's obviously with reference to the NPSUD policy 2, at least sufficient wording. So I've set out those amendments in my evidence, and I'm happy to take questions.
Excellent. Thank you very much. I'll see if we have questions for Kāinga Ora in overall terms. Andrew.
Thank you, Mr. Chair. Thank you for your evidence, Mr. Roberts. I have a few questions. So I'm just interested in 5.3. You mentioned Kāinga Ora considers the PDP does not adequately provide for the residential development capacity needed. And I guess I'm just interested, is that on the basis of supply and demand calcs that Kāinga Ora has, or is it more about a philosophical policy framework approach argument?
It's more of a philosophical approach, I think. Noting that the demand capacity assessment needs to be probably relooked at anyway, but it's more of a philosophical approach.
Thank you. One of the key things that Kāinga Ora is seeking is having a future urban zone, and you discussed that around paragraph 7.5, 7.6, 7.7. And I'm just interested in your expectations and understanding of the level of evidence required to zone land as opposed to identified under an overlay. Because often when the council rezones land from rural to urban, there are expectations around geotech, land contamination, natural hazards, and other various constraints that might apply to that land, and some initial level of assessment to assure that they actually can be used for the activity it's been zoned for. Do you anticipate that would also be done as a part of changing this overlay to a future urban zone? And if you do, who would do that?
Well, to be honest, I haven't focused on that issue today because I understand that is now being considered as part of the rezoning hearings.
Okay.
So it might be more efficient if we just provide answers as part of those hearings to that question, if that's okay.
Sure, yeah, that's fine.
Yep.
So you've proposed a change to strike in 9.4 of your evidence. You've proposed striking through the 50 dB LDN air noise contour.
Yep.
And I understand your rationale is because some development is not noise sensitive.
Yep.
Now, I'm just wondering whether you'd seen Mr. Bonis's evidence on that very point as well, where he seeks an alternative solution to strike through, which is retaining the 50. So I think he writes the 50 dB LDN air noise contour with respect to extension of boundaries to establish noise sensitive activities. So he limits it to noise sensitive activities only. And I'm interested whether that would also be acceptable to you as a solution to the issue you raised.
That's one way of doing it, but in my view, the policy wording talks about areas rather than activities. So it really confuses things if you start talking about what types of activities are occurring. Because it says avoid the following locations and areas when zoning land to extend township boundaries to establish new urban areas. So I think it's much cleaner just to delete it and enable the consideration of activities to occur as part of any Section 32 analysis of what would happen in that area. And obviously one would need to tie their thinking back to the RPS, which specifically talks about no noise sensitive activities occurring within the contours. So I just think it's cleaner to delete it in total.
Yeah, okay. Cleaner on the basis of drafting, but not necessarily wrong, though.
Not necessarily. No, not what Matt's not. No, what Matt's saying is not wrong. It's just a cleaner drafting method, in my view, to delete it the way it's worded.
Okay. And I guess I'm interested in paragraph 13.1, 13.2, 13.3, and then your recommended changes in 13.7. It's around deleting that extension as assist in meeting the minimum or the housing bottom lines. So just for clarity, you're interpreting that on that if all those bottom lines are already met, then you don't need to do any new growth areas. Is that your interpretation?
Well, yeah, that's the way it reads. Any new growth area within the Greater Christchurch area shall only occur where extensions assist in meeting those bottom lines. So the concern I have is obviously the MPSUD now says more is better effectively, provided you meet a well-functioning urban environment type approach. So the way that reads currently is that one could have an interpretation to say, well, we're over those minimum bottom lines now, so you don't fit that policy. So that's
sure. No, that's helpful, because I think when I first looked at that, I thought it was more around the type of residential activity that's being proposed, like large lot residential in an area that's highly constrained by geotech and stormwater, and actually it would not assist much at all in achieving those bottom lines, even though it's rezoned isn't it, for urban growth matters.
No. Okay.
Yeah, that was all. No, just thank you for clarifying that. And that was my final question. Thank you.
Thank you. Lindsay?
Thank you, Mr. Roberts. I recall at the strategic directions hearing that we had quite a discussion about the placement of urban growth objectives and policies, and I see you've agreed that the policies should remain in the urban growth chapter, with the urban growth objectives going to the strategic directions. Strategic directions, as currently drafted, already has an all-encompassing objective relating to urban growth. And I'm just wondering, in terms of the structure of the plan, does it really matter that the specific and more detailed urban growth objectives need to be in the strategic directions chapter? Because automatically you're going to get referred to it anyway by virtue of there being an overarching strategic direction objective anyway. Does it really matter?
To me, it does matter because of the hierarchy of the plan and the way the objectives and policy framework is set up. So obviously the strategic directions chapter is at the top of the hierarchy, and the detail that's provided in the urban growth objectives is very helpful in providing a very clear understanding of the way in which the urban area should grow, for example, and I think that should sit at the top of the hierarchy. So my view is that it's a better approach that they are merged into the strategic directions chapter.
Okay, well, conversely, wouldn't you also say natural hazards, for example? Wouldn't that also apply? As you know, the natural hazards objectives in the natural hazards chapter, or should go into strategic directions. What's the difference there?
I'm not sure about that. I think that urban growth is a clear directive in terms of putting those issues in terms of the planning standards into that chapter. So I'm not. I don't think you'd need to extend it to natural hazards.
Yeah, no. I'm thinking about, you're the only submitter, as far as I'm aware, who's requested this.
Yes.
and most other submitters appear to be comfortable with the framework. It's strategic directions at the top, and then you drop down into the level of detail as necessary with objectives and then policies in each of the related chapters.
Yeah.
Which is why I question would, if you are looking at presenting an argument where the urban growth chapter is in play, you would automatically go to that after the strategic directions. I understand your position. But I'm just thinking, well, if you're going to make it for urban growth, then presumably you'd also have to look at the other constituent parts of the plan as well. And I'm just trying to find out why urban growth is so special that it needs to be, all of the urban growth objectives need to be in the strategic directions.
Well, to me, the strategic directions chapter is primarily about how a district grows over a medium term. And, I'm of the firm view that I think to avoid the chapters saying slightly different things and to avoid people always having to go to the urban growth chapter to look at how the detail should pan out, I think, and given the hierarchy of the plan, I do think it should be merged, and they should be merged as one cohesive set of objectives into the UFG objectives. Yeah, I hear what you're saying too, but that's my preference in terms of how it should be drafted.
Okay, thank you. One more question, and leading on from Commissioner Willis about the air noise contours. To me, and looking at Mr. Bonus's evidence as well, there probably is a fairly elegant drafting solution to overcome that particular issue about noise-sensitive activities within the 50 LDN noise boundary, as opposed to completely removing it. Do you not feel that you still feel it needs to be deleted in its entirety?
Well, I mean, as I mentioned in previous questions, the way the policy is worded, it does not define for any other type of thing. It does not talk about activities. So it talks about areas and locations. And so the way I read that policy is it said these are the key areas to avoid. And then once you, if you're able to establish an activity within those areas in terms of that policy, then you look at the appropriateness of the activities themselves. So to me, it's much cleaner to delete it. But as I said in my previous answer, what Mr. Bonus has come up with, from what I understand, is not wrong, but it's my preference, and it's a cleaner drafting style just to delete that reference to the air noise contours.
Okay. Thank you, Mr. Roberts.
No problem.
Malcolm?
Yeah, thank you, Mr. Roberts. I just want to investigate the changes you wish to make to UGP 12. We want to strike out and the aligning and zoning subdivision development network capacity and availability of existing planned infrastructure and public transport services. I'm just somewhat concerned. This is a plan to the future. We have to think of our carbon futures, and our roading networks are already under some pressure as we speak at this present time. To achieve mode shift to public transport, the most efficient time for that to achieve is when people actually move house and start to take a different route to work. That's when we can achieve mode shift. And I was just concerned that in your submissions, you don't seem to be thinking of our carbon future.
I definitely am thinking of that. It's at the forefront of my mind as a planner working across New Zealand. The policy at the moment, the heading, the preceding paragraph of the policy talks about ensuring zoning of land to extend township boundaries to establish new urban areas demonstrates how it will integrate with existing urban environments, optimize efficient, cost-effective provision of infrastructure and public transport. So it's already, the policy at the front paragraph is already dealing with public transport. What I'm saying is that zoning should not be precluded or held back if the public transport service has yet to be planned. The public transport service, from my experience, always comes after the zoning pattern is known, and after the first, usually after the first stage of development is nearly completed. So I think it's inappropriate to require zoning to align with public transport services because they're very unlikely to be known at that time of the zoning going through. It still means that, yeah, sorry.
Yeah, I just, perhaps that is what's happened in the past, but for enabling us to move forward, we do need to plan for that as we go ahead.
Yes, yeah, but the policy also talks about the availability of existing or planned infrastructure. Planned infrastructure includes public transport infrastructure. So you need to make sure your zoning framework lines up with the infrastructure necessary to take a bus service. But in my view, you don't need to have the bus service work through in its entirety and fully funded, etc., before you enable the zoning to go through. That will follow later.
Okay, I think yeah, bus service, we're talking public transport, we're just not sure what that might be. But thank you very much, Mr. Roberts. That's all I have.
Thank you, Nicole.
Yes, the policy 9, where you want to delete what's been proposed and adjoining rural land. So we had Hort NZ who came and spoke to us yesterday and talking about importance of the highly productive land and being able to use it or continue to use it for rural production. And concerns raised was actually that when you've got the urban, from my understanding of what was said, when you've got the urban fringe is actually really close to what they're doing, sort of limits. So therefore, the and adjoining rural land was what they would like to see. What is your view on that when you're looking at it from obviously you guys are looking from a housing perspective and utilising land?
Well, in my view, that policy is talking to highly productive land and the focus is on highly productive land for rural production. And if that's the focus, adjoining rural land should be taken out. If it's a reverse sensitivity issue, then it's probably a different thing that should be expressed somewhere else in the policy direction. I haven't looked at that, but it's the way I read that policy. It's about protecting productive land, and adjoining land is not necessarily productive land. So, yeah, that's why I've recommended deleting that. If it's a reverse sensitivity issue, then I'm not sure whether that's covered elsewhere in the policy direction, but it sounds like that's their issue.
I think policy 11 might cover that, Nick.
Yeah.
So the combination of the two will create that safety framework.
Yeah, sorry. Yes.
So you're talking about part 1 of that as well.
So I think the point that Kaingaora is raising is that you need to be careful not to be protecting highly productive and adjoining land if the real issue is a reverse sensitivity effect on that adjoining land, and that those policies should be specific to reverse sensitivities, because they are different things, and the way that you deal with them might be different depending on whether it's trying to protect the resource for its inherent value, or protect the resource because you don't want it to compromise the inherent value of the highly productive adjacent land. And I think we're just pointing out that the amendment that is proposed has the ability, I think, to be more constraining than it needs to be for the effect that it's endeavouring to deal with.
I thank you for that clarification. Just a point of clarification for you. Para 11.5 so that's under policy 10. I assume it says I therefore support the wording of UG 01. I assume you're meaning UGP 10.
Yes. Yep.
Just thank you.
Thank you, Deborah.
No questions.
And Mark?
No questions, others have already asked them.
Yep. Raymond?
No thanks.
Yvette?
Kia ora, no thank you.
Gary.
Thank-
Mr. Roberts, just one query from me in terms of UGP 12
Yes.
and your concern about the words and public transport services. I didn't quite catch what you said in your verbal presentation, but is that founded on the fact that transport facilities, public transport facilities are already referred to in clause 5 of that provision?
That's definitely part of it. Yes. So the public transport infrastructure, in my view, is a relevant consideration when you're looking at zoning, i.e. whether or not the infrastructure can be funded and provided. But the services themselves, in my view, should not be a limiting factor on zoning because that can come later.
Yep, I appreciate that. All right, thanks very much,
Thank you.
Aurora, for coming in this morning, presenting to us and answering our questions. Thank you.
No
Thanks.
problem. Thank you for your time.
Well, we're running well behind schedule, but we'll still take a morning tea break, but only for 10 minutes, and we'll reconvene at 11 o'clock. Thank you.
Can I just let you know, I'm at council, so I missed quite a bit of what the last presenter actually said.
Well, I'm not sure what I can do about that, Deborah.
And I didn't even have, oh, hang on. I didn't even have his statement, summary statement. I went searching for it and I couldn't find it.
Grace has been emailing them to us last night and this morning, the summary statements of all of today's presenters. So they've come into my email inbox.
Well, I've done a search on my emails and nothing's coming up under kind order.
Yeah, no, I haven't then received them all either, if you've received them.
Yeah, I'm having trouble with my email at the moment. So just to top it all off, I see them coming through on my phone, but my machine's died. I'm Spring IT and well, we're having a cup of tea.
Yeah, Rob, we didn't get anything from KO in terms of the summary statements. We certainly have from...
KO didn't present any summary statements. They were all referring to their pre-circulated documents from ages ago.
Yeah.
The other earlier submitters have provided summary statements, which have all been emailed out.
That's right.
And if
Well, I think we've been sent everything which has come in.
That's correct.
Yeah.
Yeah, I found the KO stuff in the files we had.
That's where it was. Yeah, there was no new information.
Yeah, no, I couldn't find them.
Okay, well.
But it's all good.
Cup of tea time.
Paul, are you kind of free for a second? Oh, 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 good on you. Get a hat. Get a hat. It's getting cold out there. I'm in hearings at the moment, and a whole lot of information's come through, and my Outlook won't connect to the server. Yeah, it won't connect to the server. Yeah, no worries, man. I'll just put the jug on because I'm at the tea break. Oh, several weeks ago. Having trouble reloading your feed. Check connection. Yeah, I'm in there. It worked this morning at 8:57 a.m. and now it says it's disconnected. It's the laptop. The iPad.
The only option was to reboot my computer. Can you hear me?
Good morning, everyone. We'll resume the hearing of submissions. And at this stage, we're hearing from Christchurch International Airport Limited.
Thank you. Now, I did not file any legal submissions specifically in relation to this chapter, but then it just occurred to me that I may not have explained to the panel that what I was going to briefly speak to was some supplementary legal submissions that were filed on the strategic directions chapter on the 3rd of September. So I have just asked Emma to recirculate those. They're just a couple of pages. So I'm just checking that that's been done. And you should also have a summary of Mr. Bonas as well that's been circulated this morning. So just to make sure, in particular, the commissioners on Zoom have those 2 documents. Nobody's indicating they don't.
Yep, so just received on the email your Christchurch International Airport Limited further legal submission.
Yes, thank you. So this was some supplementary legal submissions filed in strategic directions chapter, and these submissions were filed in response to the panel's minute, allowing parties the opportunity to respond to matters set out in some legal submissions I'd filed for Carter Group. So this was me responding to myself on behalf of CIAL. So I was just going to start at paragraph 4, and that is CIAL's position with respect to the interpretation of the NPS UD, which unsurprisingly is not different to the interpretation that Carter Group has, just with some nuance, however, in the context of strategic infrastructure. So at paragraph 5 of those submissions, the NPS UD directs that local authority decisions on urban development are integrated with infrastructure planning decisions, and that planning decisions contribute to well-functioning urban environments, as we've heard this morning. So CIAL submits that a well-functioning urban environment is one in which infrastructure, particularly infrastructure such as an airport, is not adversely affected by incompatible activities, and that urban growth is planned with infrastructure provisions in mind, recognising that the 2 run hand in hand. Policy 8 requires councils to be responsive to plan changes for unanticipated or out of sequence development that will provide significant development capacity and contribute to well-functioning urban environments. Policy 8 does not require councils to grant a plan change, but does provide an avenue for plan changes which are out of sequence or unanticipated to be granted if they meet that criteria. Councils are not able to dismiss such plan changes purely because they propose out of sequence or unplanned development. That's what we've heard this morning. So as I said this morning, policy 8 must be read in the context of the other policies in the NPSUD, and it is one of many policies which must all be given effect to by Environment Canterbury and this council. The NPS provides for a balance between the need to provide for urban development capacity and other important countervailing issues, and one of those is protection of strategic infrastructure such as the airport. So we say that policy 4 acts as a caveat on the application of policy 3, which provides the core direction of the NPSUD. Policy 4 requires that regional policy statements and district plans applying to Tier 1 urban environments modify the relevant building height or density requirements only to the extent necessary to accommodate a qualifying matter. And we just point out that qualifying matters include relevantly any matter required for the purposes of ensuring the safe or efficient operation of nationally significant infrastructure. The provisions in the Canterbury Regional Policy Statement applicable to the 50 DBA LBN contour, such as in particular the avoid policy in 6354, are in place for the purposes of ensuring a safe and efficient operation of the airport. So we say this squarely meets the definition of being a qualifying matter in terms of the NPSUD. The NPSUD requires councils to account for that requirement to avoid development of new noise-sensitive activities within the contour when implementing the NPS and identifying areas for urban development. The NPS does not specifically state that Policy 4 is applicable to a situation in which Policy 8 applies. However, Policy 3 and 4 demonstrate the overall context and thrust of the NPS, so that CIL submits are relevant to the application of Policy 8. When considering a plan change to rezone a particular area of land in a district plan, a territorial authority is required to ensure it will give effect to both the NPSUD and the RPS, which contains the avoid policy in respect to the 50 LDN. The NPSUD will be highly relevant to any proposed rezoning for urban development. However, it will not be the sole consideration. Territorial authorities must also give effect to the relevant provisions in the RPS, which would include Policy 6354 if a plan change related to areas within the air noise contour. A territorial authority presented with a proposed plan change to provide for urban development in an unplanned way or in a way that was out of step with the provision in planning documents would need to apply NPS Policy 8 and have particular regard, firstly, to the significance of the development capacity provided, but in particular, whether it contributes to a well-functioning urban environment. As noted above, CIL submits that a plan change which proposed urban development or intensification in an area that was within the 50 LDN air noise contour would not be a plan change which would contribute to a well-functioning urban environment. The territorial authority must still give effect to the strong policy direction in the RPS 6354 that if land subject to a plan change is within the 50 LDN or similar relating to the protection of regionally significant infrastructure, the RPS and NPS must be read and applied together. So that's a long way of saying what I said this morning, except to say that a development which proposed urban growth within the 50 LDN contour would, in my submission, not meet the definition of well-functioning urban environment.
Thank you. Is it all right with you if we hear from Mr. Bonus and then we'll put questions to you both generally?
Yes,
Mr. Bonus, can you pull your microphone?
Just one matter, which is just an evidential matter. So we had indicated it's strategic growth we were up to with the remodelling of the contours. Ms. Black will give some evidence on that. So just to let you know where we're up to, the airport has completed its process of remodelling the contours, and it has provided those remodelled contours with a very comprehensive report in draft form to Environment Canterbury. And the RPS contains a method which now requires Environment Canterbury to have a technical peer review panel, which will review what CIL have delivered to them. And I think there's a tender proposal on GETS at the moment. So they're just in the process of assembling the review panel. My understanding is that the City Council, the Greater Christchurch Partnership might be also interested in that process in terms of some of its constraint mapping for its own process that it's going through. So I don't know, Felicity, if you know what the time frame is, but they're certainly setting up their technical review panel at the moment. So they are correct insofar as CIL is concerned, but they have not been peer reviewed by Environment Canterbury. We've missed the boat, obviously, in producing the contours and requesting any sort of rules or relief around them for this process. But we are wanting to rely on them evidentially in terms of where noise effects will be experienced for the rezoning hearings. And it did occur to us that it's probably a bit late for some of the rezoning applicants if the first they see of it is in our evidence in reply to the applicant's rezoning evidence. So we were proposing to put the information in with our evidence on the noise chapter, notwithstanding that we're not seeking any relief, for example, but we just thought in fairness to submitters, they might want to see that earlier and later. So I'm trying to devise a way of getting the information in front of the panel so that's available before rezoning evidence is due from applicants. So we'll put it in as part of our noise evidence more as an FYI than anything else. there have been a number of Official Information Act requests, so a number of parties have already received the material, and I think it's going up on CIL's website. It has already? It has already. So it is available for the public if they know to look for it at the moment. Waimak Council's plan process submissions finished last Friday, so we did put them in with that submission insofar as Waimak's concerned, but obviously we were too late for this process. So that's where it's up to. That's just information for you more than anything, and it's not really going to become relevant till we get to any particular rezoning hearings that might fall within the remodel contours. But thought it was important to get it to you and get it to the public as soon as we can, even if not technically relevant for the noise chapter hearing.
Yeah, well, thank you for that. I'm chairing the noise hearing, so in the absence of conferring with my 3 colleagues, I think that's a sensible suggestion. And if you did do that, if it just could come with whatever brief explanatory material would help us understand the information, that would be helpful.
Yes.
Okay, thank you. So if we have, Mr. Bonus, thank you.
Sorry, I was just making notes of what my noise evidence needs to contain. I'll be remarkably brief because I think I can. There's a large degree of agreement with the Section 42A reporting officer in terms of the urban growth proposal. I've provided a very short 3-page summary in terms of where we are, and part of that is to respond to the questions around UGP 11. Which Mr. Bard was asked to sort of reflect upon in terms of some questions from the panel. So I'll just quickly and briefly go through this. I think 1 and 2 can obviously be read. 3 simply suggests what I've talked about now in terms of what's here. So in terms of 4, as identified in my evidence in chief, there's largely agreement between Mr. Bard and myself as to the provisions. Residual matters, and they're very narrowed, relate to the manner in which both operation and broader development are referenced in UG 01 and UGP 11. Amendments to UG Schedule 1, a very brief matter just in terms of the addition of or avoid in Clause 3D. And Section 42A amendments to UGP 11 around the phrase or the threshold of significant for adverse effects. So in terms of incompatibilities of urban growth and operation development of important infrastructure, both UG01, that's the what, and associated policy UGP 11, the how, seek to recognise and preclude sensitive urban growth from encroaching on important infrastructure. Both the Section 42A reporting officer and I agree that the principle of reverse sensitivity on such infrastructure is appropriately recognised in the proposal in the manner established in the Canterbury Regional Policy Statement. And I've identified those objectives and policies there, and I don't need to take the panel through them. I've seen them several times within my evidence. At 7, the matter of disagreement is narrowed to how such important infrastructure is referenced in these provisions. Mr. Bard seeks a narrow reference to operation, whereas I've recommended inclusion of the more fulsome use, development, appropriate upgrading and safety of. And the basis of that recommendation is these are the terms that are used in the RPS, and hence proposed Selwyn provisions could be interpreted otherwise as narrowing the extent of considerations. Both the notified strategic directions proposal and any amendments sought in my evidence in chief to that proposal reference both operation and development, upgrade and maintenance. And I understand that operations can be interpreted in sort of the Oxford Dictionary means in the more present text and does not necessarily encapsulate anticipated future growth. CIL's 50 dBA airport contours are perhaps a case in point. The current noise level that might be experienced is well below what the 50 dBA contours are actually looking at providing. Essentially, it's a bucket that fills over time. So the current operations aren't actually producing the noise that the contours are designed to provide for. My recommended provisions on both UG01 and P11 are set out in 24 of my evidence in chief. In terms of UGP8, constraints on township boundaries, and it was comforting to hear Nick suggest that I might not be completely wrong on this. The purpose was to sort of suggest quite a blunt submission from CIL that was agreed to by the reporting officer, and I certainly agree on the principle and the premise, but the provision's more nuanced around only precluding noise sensitive activities. Industrial zonings would well be fine. And I also take the Commissioner's point made over Zoom that, with some polishing, if there's still an issue, then that would certainly be my preference. I would have considerable hesitation if it was removed altogether, given the strategic importance of that constraint. For my part, I'm actually quite comfortable with the way it's drafted. It very much has brackets sort of identifying what the nature of the restriction should be in relation to locations and areas. So I'm actually quite comfortable with how the wording's landed. In terms of Schedule 1, I agree with the Section 42A reporting officer that there's sufficient clarity between policy and the purpose of Schedule 1 without the additional clauses and cross-referencing sought by CAL and the CAL submission. Effectively, I think Mr. Bard identified that there would be increased prolixity and it was unnecessary, and I agree with him. However, at paragraph 33 of my evidence in chief, I've identified that Schedule 1 provision 3D be amended to include or avoid in relation to the methods to be shown on an ODP. As identified in the CRPS provisions above, avoidance is envisaged, and RPS policy 339, which is the one that governs ODPs for development areas, shows how identifies that it can show how adverse effects on strategic infrastructure will be avoided or remedied or appropriately mitigated in terms of the way that that clause is referenced. In terms of UGP 11 changes, Mr. Bard, in responding to the panel's questions, has sought to amend UGP 11 as follows, and I've set that out. And I've also identified his paragraph 24.9 in terms of his response to the panel as to why he made that recommendation. Now, I understand the panel's question was predicated on the very directive language of avoid adverse effects, and essentially seeking some qualifiers in terms of what that means. In response, I note the following. The CRPS provisions as above uses such directive language, albeit with a slight nuance that new development does not adversely affect the efficient operation, use, development, appropriate upgrading and safety of. As discussed in my strategic directions evidence, a threshold predicated on establishing a significant adverse effect can lead to cumulative effects, ultimately affecting the integrity of the provision and the important infrastructure to actually be recognised. And I've identified where that is. And I must admit, I've turned up for a number of hearings on behalf of Christchurch Airport in terms of noise sensitive activities within the contours, where the overall conclusion is that this individual one may well have a minor effect, but if you put a large number of those together, the integrity of the provision dissipates quickly. Lastly, the recommended syntax provided by Mr. Bard would seem to indicate the reverse sensitivity effects considered less than a threshold of significant would be tolerated by the policy. Now, in my view, that would not give effect to the RPS provisions as I've identified them. Alternative wording, which could more appropriately account for both the directive language in the RPS and the nuance, is suggested below. And essentially, I've removed Mr. Bard's reference to significant adverse effects and simply referred to and ensures development does not adversely affect. And that is the wording pretty much word for word from what's within the RPS provisions in terms of reverse sensitivity. I'm happy to answer any questions.
Well, thank you very much to both of you, and Mr. Bonus, it's a very helpful and concise summary of the current position. I'll just see if we do have any questions of clarification for you or for Ms. Appleyard.
Thanks,
Andrew.
Thanks, Mr. Chairman. Thank you for your evidence, Mr. Bonus. I had one question, but you've covered it.
Clairvoyancy.
Thank you. Thank you for the questions.
Excellent. Lindsay?
Yeah, I've just got one real question as well. This is in relation to your suggested changes to efficient operation, use, development, upgrading and safety of. If you think of the airport in the context of Selwyn, that the airport is not actually located in Selwyn, and the activities which occur in relation to Selwyn are in relation to the the potential for air noise. If you actually unpick that and you have a look at the operation of the airport, which is understood, it's the aircraft, etc., flying around and so forth. But does, in the Selwyn context, does it actually need use and development and appropriate upgrading? Because the airport's not actually going to be appropriately upgraded within Selwyn. It's in Christchurch, I understand, and the same relates to safety. Do you have any comment on that view? Why couldn't it just deal with the efficient operation?
I guess it goes back to the point that I was trying to sort of identify earlier, that I see operation as being the narrow what and sort of the present tense, what it's currently doing. The syntax of the way that the provisions are drafted It's about avoiding future zoned land to avoid reverse sensitivity effects, essentially in this particular instance on a future noise bucket. And I think quite appropriately, that future noise bucket at the airport is predicated on a number of things, including increases in flight numbers, frequency, and reorientation and reorganisation accordingly. And that's quite rightly put within the RPS provisions. And I think that's one of the reasons why the contours provide sort of that future projection, and also why it's sort of stipulated at that regional level. So I think it is appropriate for the provisions in the Selwyn plan to recognise reverse sensitivity as something that's going to happen based on the future operations. I probably can't elaborate much more on that.
Yeah, but obviously that's the operation of the airport, which I think is well accepted. I guess I just struggle with use development and appropriate upgrading of the airport itself, and what that might mean to the areas of the noise boundary within Selwyn district.
I guess in terms of looking at the provisions, and I'll use P11 as an example, it talks about when zoning land to establish a new urban area or extending township boundaries.
Yeah.
Avoid adverse effects or avoid reverse sensitivity effects on the safe, efficient and cost-effective operation. And I guess my inclusion of putting use development and appropriate upgrading makes it abundantly clear that it's in relation to how those operations, even though they're not within the Selwyn boundary, will increase over time. You could quite rightly get a sensitive activity establishing in Selwyn that is currently at a level below 50 dB in terms of its receiving environment, but the future development and use of the airport will in time load a noise level on that will well exceed that. So I understand the point, but I think the critical issue is, where is that reverse sensitivity effect felt? And it would, as a consequence of where that reverse sensitivity effect being felt, preclude, I guess, the use, development and appropriate upgrading of, in this instance, Christchurch International Airport.
Okay, all right. No further questions.
Thank you, sir.
Just in response to that issue, is the answer as simple as that? UGP 11.2 is not an airport-specific provision. It relates to important infrastructure, land transport infrastructure, and a strategic transport network, of which CIA would be a component, but it's a much broader policy, isn't it?
Correct, and there's a number of provisions Selwyn-based that actually give effect to that policy within the Selwyn district.
Yeah, okay. Malcolm?
No questions, thank you.
Nicole?
No questions, thanks.
Deborah?
I've just got one, and it's just to understand with regards to the development of the airport, are there any radio frequency infrastructure established in Selwyn that actually helps the planes to go on a certain course that needs to be protected as well?
Ms. Blackmore's just indicating that if there is that infrastructure, that is the responsibility of Airways, not of Christchurch Airport. So Christchurch Airport's own infrastructure is only that which it has within its special purpose zone and its designation. So if there's any of that, a beacon or something of that example, I'm making it up here, I'm not a pilot, that would be the responsibility of Airways.
Okay, thank you.
And Mark?
Yeah, thank you. Just have one question about when you talk about appropriate upgrading, does that imply that there might be an inappropriate upgrade? Does that open you up to challenge that when you want to do an upgrade that somebody could say, well, actually, that's not an appropriate upgrade, and therefore you haven't actually closed the door, you've opened the door to a challenge on the basis of whether your upgrade is appropriate or not. And that's where I just concerned at your or some other infrastructure upgrade, that whilst you're trying to protect the ability to upgrade your infrastructure. By saying appropriate, you're actually opening the door to someone challenging it and saying, well, actually, it's not appropriate. So the use of that word, is that actually opening a door you didn't want to?
It's a very good question. The wording itself comes from Objective 621, Clause 10 of the Regional Policy Statement. And I think it's designed to ensure that when a district authority designs its district plan, that it sets out quite rightly what is appropriate and what is otherwise in terms of upgrading for particular infrastructure. So it allows some nuance in terms of setting plan provisions at this level as to, well, we're going to allow these things, but not other things. And then that would give effect to this particular provision. So the setting of what's appropriate and what's inappropriate in terms of infrastructure won't be the airport in this particular instance because we're out of the district. But it allows for example, the Orion network for you to consider what utilities and additions and add-ons would be appropriate and therefore tick that box and which ones wouldn't.
Thank you.
Raymond?
No, thank you.
Thank you. Yvette?
No, thank you.
Thank you. Gary?
Thank you. Yes, I just wanted to look at UGP 11, the alternative wording. That's the last part of your statement today. I think I understand it, and I've been considering it in the last few minutes. Just wanted you to clarify a couple of things, Mr. Bonis. It looks like there's an attempt there to focus on reverse sensitivity effects as being the key effects. Before it was including reverse sensitivity effects. That would accord with the airport's main concern, wouldn't it? Is it mainly about reverse sensitivity rather than other effects?
For the airport, it is. This policy's got a bit of a checkered history in terms of what was notified and the mechanics to what's currently been there. So what I've tried to do is reflect both reverse sensitivity effects and sort of those broader adverse effects. And I think we've talked through those quite a bit on strategic directions as well. But I'm completely agnostic in terms of the order, in terms of or the priority, but it's just making sure that both those principles are covered off.
In the way that's given effect to, it's talking about zoning land, isn't it? So the zoning of land, avoid would mean things like whether it's residential, industrial zoning, that sort of thing. And the words you've underlined, and ensures development does not adversely affect. Would that be implemented through rules in the zone? Is that how it would work in practice?
It would, but it could also be when you introduce new zoned areas, for example, through outline development plans, you might have particular, and I think Schedule 1 sort of sets that out. You might have areas where you avoid or set buffers or various other bits and pieces to achieve that policy.
That's useful. Thank you very much.
And no further questions from me, but thank you very much for coming in and presenting to us and answering our questions. Thank you. So our next submitter is Fonterra, who according to my schedule are all going to Zoom in. Grace, is that correct? No. Oh, okay. Yep, good. Sorry about that. Right, good morning and welcome. Perhaps just before you commence, can you just briefly outline the actual documents you're going to speak to this morning? We've had some summary statements presented and emailed out, but I'm not sure if everyone's received them. So if you could just say which documents you're going to speak to this morning before we speak to them, that'd be great. Thanks.
Certainly. So, tēnā koutou katoa. I'm Rachel Robilliard from Chapman Tripp, appearing for Fonterra this morning, and I'm joined by in person by Mr. Llewellyn, who's Fonterra's National Consents Manager. And then on Zoom, we have Mr. Vikes, who's Fonterra's Regional Farm Operations Manager. And we have Ms. Tate, who's Fonterra's expert planning witness for this hearing. The documents that will be being spoken to Mr. Llewellyn, his summary was provided via email last night, along with 2 maps of the Fonterra Darfields irrigation system. We also have hard copies available if need be. And then this morning, possibly shortly after 10 a.m, we also emailed a summary of Ms. Tate's evidence. So those are the key documents that will be spoken to, along with the legal submissions and evidence filed.
Great, thank you very much.
So just to briefly cover off, we filed very brief legal submissions in relation to this hearing, which once again is in relation to Fonterra's Darfield milk processing site. And in regard to the urban growth provisions, Fonterra is seeking a number of amendments to protect the Darfield site and associated irrigation farms from reverse sensitivity effects, to ensure that the use, development and appropriate upgrading of important infrastructure is protected from reverse sensitivity effects, and to remove the urban growth overlay from the northwest of the Darfield township, which Fonterra is concerned has the potential to have significant adverse effects on its adjoining wastewater irrigation farm. And so in relation to these issues, evidence was filed for Fonterra in August from Ms. Tate in relation to the planning matters, and from Ms. Buckley, who at that time was Fonterra's National Policy Manager, providing an overview of the operation and importance of the wastewater farms at the Darfield site and the need to protect these farms from encroachment by sensitive activities. The panel might recall we filed a memorandum of council in October advising the panel that Ms. Buckley has since left Fonterra, and so Mr. Llewellyn is attending with Mr. Vikes' assistance in her place. And if there's any questions that aren't able to be answered in person, we'll endeavour to answer those in writing. And in addition to those documents, we've also, for Fonterra, filed evidence for the strategic directions hearing, and also the planning evidence for the energy and infrastructure hearing, which of course is relevant to these issues as well, particularly in relation to the significance of the Darfield site. So as mentioned, Fonterra is seeking a number of amendments to the objectives of policies, which we haven't discussed in the legal submissions and will be addressed by Ms. Tate shortly. So the key issue that I'll briefly speak to is the proposed urban growth overlay on the boundary of Fonterra's wastewater farm on the outskirts of Darfield. And for context, there's a map both in the evidence of Ms. Buckley on page 4 and Ms. Tate on page 7, which shows the particular Fonterra property in red outline adjoining the yellow hatched urban growth overlay. And then there's also the 2 additional plans that Mr. Llewellyn will speak to. So Fonterra, in its submission on the proposed plan, opposed the urban growth overlay over the land adjoining its wastewater farm and sought that the urban growth overlay was deleted, retaining the underlying general rural zoning. The reporting officer recommends that Fonterra's submission point is rejected on the basis that any reverse sensitivity effects can be dealt with as part of a future plan change process to change the zoning of the site. The reporting officer places significant weight on the Melbourne Area Plan, which is a non-statutory plan that was intended to provide, this is quoting from the plan, high-level planning direction to guide the growth and sustainable development of the Melbourne area, and identifies this land as a potential future development area for low-density residential development, while identifying the land to the north as being consented for the Fonterra discharge. Fonterra does not agree with the reporting officer's position in respect of this submission point. And to summarise across the evidence, Ms. Tate set out that there is more than sufficient housing capacity in Darfield for undeveloped living zone land to satisfy requirements well beyond the life of this proposed plan.
The Canterbury Regional Policy Statement recognises that rural residential development should be limited. The Melbourne Area Plan recognises the need to manage growth to protect Fonterra's wastewater irrigation farm from reverse sensitivity effects. And the plan approaches the issue of avoidance of such effects in what is Darfield Area 1 in the Melbourne Area Plan. And I've quoted from that plan in my legal submissions. But despite this, the urban growth overlay does signal to the landowner and the community that urbanisation of this land can be reasonably expected, favouring the rezoning of this land over land not subject to the urban growth overlay. Ms. Buckley explained in her written evidence that maintaining sufficient wastewater irrigation land capacity is critical for the ongoing year-round operation of the Darfield site, and that establishment of dwellings on the proposed overlay land would result in adverse effects on those residents, and it would not be possible to avoid reverse sensitivity effects on Fonterra, or it would have the immediate effect of significantly reducing land available for irrigation by introducing further setback requirements. And in relation to the strategic directions evidence file for Fonterra, we explained that reverse sensitivity effects are not only expensive and time consuming for Fonterra, but also reduce the likelihood of further development of the site in the future, which presents significant inefficiencies and associated economic and social costs. And with reference to Fonterra's legal submissions on strategic directions, Fonterra's wastewater irrigation farm is a good example of a situation where total internalisation of effects is not feasible, and there is no requirement under the RMA that this must be achieved. So against that summary, it's also important to acknowledge that the Melbourne Area Plan is not on its own an expert witness. The plan only attempted to identify potential growth areas, and there should be no assumption that any one site is suitable for rezoning. And in this instance, it submitted that it is best regarded as a non-statutory document that has been superseded by consented urban growth in other parts of the Darfield township. And although it itself acknowledges the potential for adverse reverse sensitivity effects on Fonterra, it does appear that it has been prepared without a full appreciation of what the direct effects would be on the residents. And similarly, would have been prepared without evidence on the extent to which adverse sensitivity effects on Fonterra can actually be avoided, and that it should not be favoured over the clear and much more comprehensive evidence presented for Fonterra that both the urban growth overlay is not necessary, nor is it appropriate in this location. So in summary, Fonterra seeks the relief in its submission as amended by Ms. Tate's evidence.
Thank you very much. It's a very helpful summary of Fonterra's position. Would it be all right with you if we heard from Mr. Flewellen and Ms. Tate, and then we'll see if we have questions that can be put to you collectively and just the best person can answer them?
Absolutely,
That's
sir.
it.
I'll
Okay.
hand over to Mr. Flewellen.
Yes, good morning. My understanding is you have a summary document in front of you. I wasn't intending to read it all, but if you'd like, I'm happy to do that. Take your advice.
And perhaps if you could just start at para 7, because it's new information, and just read that through for us, and we'll follow it on our screen.
Yes, no problem. Fonterra has opposed the proposed urban growth overlay that immediately adjoins the boundary of its Racecourse Hill irrigation block. Fonterra is concerned that the proposed UGO, which effectively signals the future urban use of the land, would support the development of a new residential area on the boundary of the Racecourse Hill block. This would negatively impact upon the future operability of the wastewater irrigation farm. Reverse sensitivity is a key issue for Fonterra. Despite being compliant with resource consent conditions and permitted activity rules in the relevant plans, complaints are still made by sensitive and incompatible activities, as typically it is the perception of what is appropriate or what compliance should look like that is the issue. This is particularly the case where new residents' expectations of amenity are akin to those that would be found in an urban environment. Fonterra is required to locate its irrigation operations on the Racecourse Hill block at least 100 metres from any dwelling, irrespective of whether it is existing or new. This is to provide a buffer to help mitigate odours and spray drift between the irrigation activity and the more sensitive residential one. This setback is considered a somewhat arbitrary number because odour and whether it is offensive and or objectionable is dependent in large part on both the sensitivity of the receptor and the number of sensitive receptors. While a 100-metre setback may assist Fonterra with maintaining its current full irrigation area in compliance with its relevant consents, it is unlikely that a 100-metre setback would be appropriate to meet the amenity expectations of a larger number of houses in a new residential area to avoid reverse sensitivity effects and complaints. A consequence of this urban growth overlay proposal is that Fonterra may need to adjust its irrigation operations to accommodate the establishment of new houses. This would include setting its irrigation activity back further into the racecourse block and making adjustments to the span of its 2 centre pivots. This could result in the loss of around 14 hectares of irrigation land and place pressure on the Darfield site's manufacturing processes, particularly during the peak milk processing period. In the extreme, a reduction of the wastewater discharge capacity could limit processing capacity at the Darfield site. Given the importance of the site in Fonterra's broader manufacturing network, it is essential that there is sufficient irrigation land capacity to enable all wastewater generated at the Darfield site to be applied year-round, and that any reduction in this area due to the establishment of incompatible and sensitive activities is avoided. Thank you.
Excellent. Thank you very much for that. And Ms. Take, can you hear us?
Yes, I can. Can you hear me?
Yes, we can. So maybe if we can have your summary, and then we'll see if we have questions for Fonterra generally. Thank you.
No problem. So Fonterra sought the addition of 2 clauses to UG01 to protect both its manufacturing site and irrigation farms from reverse sensitivity effects arising from urban growth. With respect to important infrastructure, I consider that urban growth, the UG01 needs to be amended to protect the operation, use, development, appropriate upgrading and safety of important infrastructure from urban encroachment, not just the operation, to give effect to objectives 522, 621 and policy 635 of the regional policy statement. With regards to the protection of existing and consented farming practices, I consider that the reporting officer has conflated the submissions of Hort NZ and Fonterra, which has resulted in Fonterra's submission being misinterpreted and ultimately not captured in UG01. The inclusion of an objective protecting rural practices from urban encroachment gives effect to objectives 521 and policies 532 and 5312 of the RPS. I support the reporting officer's recommendation to include dairy processing in UG P11.1. However, as with UG01, I disagree that only the operation of important infrastructure should be recognised as requiring protection from reverse sensitivity effects. This, as the RPS goes further than this and protects the operation, use, development and appropriate upgrading of regionally significant infrastructure and district and the district plan should reflect this. I'm very conscious of that we've just traversed that matter with Mr. Bonas, but I'll move on. With respect to UGP 11, I also note that the panel has raised a question to which the reporting officer has responded in agreement that significant adverse effects rather than adverse effects should be avoided. I agree in part. Where the effects relate to something like transport safety, and the example I've given here is a new subdivision generates volumes of traffic that might reduce the level of service at Fonterra's access, but does not significantly compromise it, i.e. the effects are not significant, I consider that these effects could be mitigated. However, reverse sensitivity effects exist regardless of their scale, their ability to be measured, or whether the activity is complying with the district plan or not. They exist purely because a sensitive activity complains about an existing activity, and Mr. Llewellyn has been over the cost of this to Fonterra. Importantly, Objective 521 and Policies 532 and 5312 of the RPS, as well as Strategic Direction IR01, necessitate the need to avoid reverse sensitivity effects. They are explicit in their intent and to dilute P11 such that only significant reverse sensitivity effects should be avoided, would not give effect to the RPS or be consistent with the strategic directions. To this end, I have recommended the following change to P11, which, if just the first part says, when zoning land to establish any urban area or to extend any township boundary, avoid reverse sensitivity effects or any other significant adverse effects on. Next, moving on to P17, I support the changes recommended by the reporting officer to recognise highly productive land and reverse sensitivity effects on important infrastructure. Turning now to the urban growth overlay in the northwest of Darfield, as noted by Ms. Rebillard and Mr. Llewellyn, this could have a significant impact on the operation of Fonterra's adjoining irrigation farm. The reporting officer has suggested that any effects can be dealt with as part of a Schedule 1 plan change process. In my opinion, the overlay effectively signals the future urban use of the land or creates an expectation for such an outcome. I therefore consider that council needs to take a more discerning approach to the use of the overlay and undertake a rigorous analysis of whether the areas subject to the overlay satisfy the urban growth objectives and policies, rather than leaving it to the Schedule 1 process. And just here, I'll point out that the objectives and policy framework are still proposed, and they're obviously being debated through the hearing format. So at this stage, the overlays haven't been tested against an operative framework. And I'll also just note there that P14, in my mind, sends a signal that when land is subject to an urban growth overlay, it's a case of when, not if, as there's no clear signal in the policy that part of the decision making will be whether or not the development is appropriate. So moving on to paragraph 10, having reviewed the data available in the Melbourne area plan in terms of the land supply and the Selwyn district growth and demand study in terms of housing demand, I do not consider that the overlay, the northwestern overlay, is necessary to protect the reasonably foreseeable growth requirements of Darfield. And in addition, I'll just note that Plan Change 63 has recently rezoned an additional 60 hectares of land to residential and some of that to medium density, which was not considered as part of the land supply data discussed in the Melbourne area plan. The most effective way to manage reverse sensitivity effects is to avoid locating sensitive activities in close proximity to the irrigation farm. As such, I consider that the overlay in northwest Darfield should be removed, as it creates significant uncertainty for the viable operation of Fonterra's irrigation farm to the north, which in turn will impact on the manufacturing capacity of the Darfield plant that has been identified as important infrastructure. Thank you.
Thank you very much, Ms. Tate. Now I'll just see if we have questions for Fonterra generally. Andrew.
Thank you, Mr. Chairman. Just got a couple. And it's Ms. Tate, I think, principally just a question for you. So paragraph 20 of your evidence, you talk about protection of important infrastructure and the definition of important infrastructure, and you consider it central to your evidence. And you make an argument in paragraph 20 that the council has afforded dairy processing plants a status on a par with regionally significant infrastructure within the district, and it therefore stands that the same protections from urban growth that the RPS extends to regionally significant infrastructure should flow to all important infrastructure in the district plan. And I guess I'm interested in that statement. So, I mean, I understand what you're saying there, but technically, Fonterra's dairy processing plants aren't regionally significant infrastructure for the purposes of the RPS and its provisions. Is that correct?
Correct.
Right, but you're relying on those RPS provisions anyway to justify and require to give effect to those provisions for the various statements in your evidence, even though the RPS doesn't require that for dairy processing plants.
That's correct, but I do think that there has been the fact that the council has collectively defined regionally significant infrastructure, important infrastructure, and included dairy processing plants within the dairy processing zone alongside regionally significant infrastructure. I do think it's reasonable to assume that it is afforded the same protections. And yes, I am relying on the RPS, but I do acknowledge that's not what the RPS says with respect to dairy processing zones.
Yeah, look, I understand the sort of the merits argument and why you're proposing it is just clarifying, but actually, essentially though, it's troublesome to rely on those provisions when technically they don't actually apply within the RPS. So that's just my question too, but you've answered that. And my final question really is in relation to paragraph, trying to find the paragraph number. It's a long, really long paragraph, 33. But actually it's paragraph E on bottom of page 9. And you talk about notwithstanding compliance with consent conditions, some effects, although minor, can still impact beyond the wastewater irrigation farm's boundaries. And I'm just interested to know just what effects are these, and you refer to noise and the evidence of Sparkly. I'm just interested what other effects are likely to occur or do occur outside of noise.
I think odour is the key issue.
Oh, sorry, odor. My apologies, odor. Yeah.
I was referring to odour in here, but either Mr. Llewellyn or Mr. Weitz may be able to comment on some other concerns that occur at the farm, if there are any.
Yeah, just interested, generally, so I can get an understanding of the significance of the issue of having urban growth up against the boundary. So what other effects are there apart from odour?
I think in terms of this issue, odour is the primary concern where we're dealing with the boundary. Noise would be the secondary concern. I wouldn't suggest that there'll be any others particularly other than those two in terms of the boundary sensitivity issues.
So not outlook or anything like that, or character, but noise and odour are the principal ones, and they're the ones that arise through complaints or, okay. All right, thank you for clarifying that. No further questions.
Thank you. Lindsay? Lindsay, your microphone's muted.
Sorry about that. Thought I'd done it. Hasn't really been discussed in your summary at all, but I'll just go to Ms. Tate, your evidence at para 24, where you're looking about proposing an amendment to UGO 1 and looking at the addition of additional clause does not compromise existing and consented farming activities. I understand that in the context of Fonterra's particular position, but isn't that a very broad and potentially subjective objective where you have existing, you might have rural grazing, for example, it's an existing activity, and you might have something next door which is potentially going to affect that, and it's not really been manifested through. That's an outcome statement about what you want to achieve, but it hasn't really been followed through to any policy directive about how that might be applied. Do you want to comment on that?
Yes, I think it's been picked up in terms of policy 9, the amendment to policy 9, and I did
which
make
is about productive soils
and adjoining rural land for rural production. In P17, P17.1 talks about minimise the loss of the rural land resource, which would give effect to an objective relating to permitted and consented rural practices.
Okay, thank you for that in relation to policy 17, but policy 9, my reading of that is it's about protecting versatile soils, or however that may be defined, and the debate, and we've had evidence on it, is that it should not include adjoining land. I just trying to see the correlation between the objective or the addition to the objective which you're seeking and policy 9.
So one of the in the drafting of the Section 42 report, my position was that the reporting officer conflated the two issues that Hort NZ and Fonterra were seeking. So Hort NZ were seeking the protection of highly productive land, while Fonterra was seeking to protect the activities on that land. So I guess there's a a future use element versus a current use element to that. And so from that flows the logic that it requires an objective. Existing and consented farming practices require an objective in their own right. And the policy 9, which I appreciate didn't pick up adjoining rural land in the original draft, but I do think it would give effect to an objective that, because I think it talks to the issue of putting sensitive activities up against rural activities.
Okay, so policy 9 is about versatile soils and with or without the adjoining land to versatile soils. So is the Fonterra irrigation land or the area proposed in the overlay, the urban growth overlay, does policy 9 kick in for that?
Policy 9 would kick in for that because it would be it would put sensitive activities hard up against an irrigation activity.
Yeah, no, I understand that, but is it a versatile soil or adjoining a versatile soil?
I can't comment on the soils, probably. Sorry.
Okay, thank you. No further questions.
Malcolm?
Yes, thank you. Thank you for your evidence. I can understand the Fonterra's desire to protect the irrigated land, and I do recognise that noise and odour are quite common with farming practices. I can see the changes you're wanting to make and can understand why you're wanting to make them and going down this pathway. Has Fonterra thought about increasing their land holding to create themselves a buffer?
I'm happy to, yeah. So I guess strategically when the factory and the irrigation farms were first developed back in 2011, 2012, they strategically bought this land on the basis that they didn't think it would actually be under threat from urban encroachment. Was quite a good buffer distance at that time. So that was the thinking at the time, strategically, that they thought they had sufficient land. It would be very difficult to go out and find additional land that's capable of receiving dairy factory wastewater under current regulation, and it would be very costly to do so.
Yes, I imagine it would be costly to do so. But as we move forward, we're talking of a plan to the future, and Darfield's going to have sewage. I can imagine that it's not going to stop its growth in the next 50 years. So that was just my question. So thank you for that.
Thank you, Nicole.
Yeah, thanks for your submissions to us. So I've got a few more questions with your concerns about the overlay. So from my reading of what's been presented, so the overlay came out from the Melbourne structure plan process. Did Fonterra take part in that? I understand from looking on the our website that it's had a submission process and everything like that as part of it back in 2016.
We might have to come back to you on that one.
Okay, thank you for that. Now, just teasing out from what Malcolm has been asking about, so talking about land next to where you are. So just generally, you've been talking about complaints that you've been receiving. It's not that you've been receiving complaints from this particular area or not, or is it just you're saying generally that you can receive complaints from your operations?
So I can give you some complaint history with regard specifically with regard to the irrigation of wastewater on our farm. So in the last 2 seasons, we've had 9 complaints that we've got recorded. There there's further complaints going back beyond that, but that's just the more recent data. All of those complaints concern odour specifically from wastewater irrigation. They're not all specifically the pivot right next door to this urban growth overlay. They concern different parts of the farm, but some of them have been in that area as well. The most recent complaint was the 18th of November 2021, so just recently. So we're actively dealing with that at the moment. I just stress as well that these are complaints and they are not non-compliances. So the complaints that we have to address and follow up with those complainants, but they're not issues for council to have to follow up in terms of non-compliance and enforcement.
So they weren't ones that have been verified by Environment Canterbury?
Correct.
Okay, so they're just ones that have been directed directly to you people, your company?
Yeah, it's possible they've been directed to council as well, but they certainly weren't, as far as I'm aware, validated as non-compliances in terms of odour.
Okay, thank you for that.
Thank you. Deborah?
No questions from me.
Thank you, Mark.
Yes, a couple of questions. Just seeking a clarification on your map you circulated, DAR 001, labelled wastewater treatment system. Some of the pivots are green and some of them are white. Does that just, what's the difference in the colouring? Does that suggest operational versus future?
Actually, not too sure on that. Mr. Vikes, are you familiar with this map? My understanding is all of those pivots are all evenly utilised across all of that land. So I don't think there's any particular distinction there. It just might be the stage of when they were developed.
So looking at that map and the other one you circulated, you're effectively using the land in question to the as a buffer zone. You've got no buffer zone on your own land. The currently undeveloped land that could be in the urban growth overlay is effectively giving you a buffer to any residences.
That's right.
It's currently zoned general rural, so somebody may put a house on it as it stands.
That's correct. The general rural zone, I think, is a 20 hectare density limit for houses. We have that situation across many of our irrigation farms across the country. And that's I guess a tolerance that we're prepared to accept because the density is so low, and we can't expect to have zero houses anywhere near us. But the lower the density, the easier it is to manage.
So you're currently irrigating up to your boundary. So if as it stands, somebody could put a house in that block and cause you to have to withdraw from your boundary.
Yes, it would probably depend on where along the boundary. And in theory, that is possible. My understanding is that most of that land is held in one rural ownership, and there's already a house there. So what I can speak from what I've seen across all of our sites in similar sorts of environments, we don't tend to see regular influxes of dwellings and what is in their own, I guess, their farm.
Thank you. I'm just trying to explore the hypothetical because it's sort of,
appreciate
as I said, you're essentially using the neighbouring land ownership because it doesn't have a house as a buffer, as your buffer zone, rather than having to use your own land for that 100-metre buffer. So you're seeking this piece of land in question that's currently zoned rural, or outer plains, to remain in the new plan to be general rural and not become part of an urban overlay on top of that.
That's right.
But you're not talking about the land that's currently L2A or living large lot residential in the new plan that's on the other side of it. You're not talking anything about that. You're just looking at this particular block that you don't want in the urban overlay.
Correct.
Okay, well, thank you for that clarification. That's what I was just trying to get clear in my mind exactly what we were talking about.
Raymond?
Yes, I do have one question. And I'm not sure who I meant to ask it to, but it's a general question. Do you get such things as agreements in perpetuity? And I'm thinking about, when a developer puts a whole lot of subdivides, and the potential is to have a whole lot of houses, and So in that context, do you get agreements that for reverse sensitivity, i.e. no complaints, in perpetuity? Is there any such thing like that?
Oh, yeah, okay, it's me again. So we do in some instances, usually historical instances, yeah, we can have no complaints covenants put on titles of adjoining land, particularly when new subdivisions occur. It's usually when they occur very close to some of our existing factories. So yeah, that is possible. It doesn't always stop complaints, but it is possible in terms of, I guess, further legislation.
How effective are they?
It's a bit hard to know. I'm not actually aware of them coming up too much. Whether, as I said, in my experience, it won't necessarily stop subjective complaints. I believe it probably would stop someone necessarily opposing us, maybe in a more formal regulatory environment, though.
And sorry, this is just a question for curiosity. What's the nature of the discharge? Is it just wastewater? How's the wastewater made up? What's in the wastewater?
Yep, that's a good question. So yes, it's what we call dissolved air flotation treated wastewater. So the wastewater is made up. So if we use raw water for cleaning the insides of the tankers and the insides of the processing plant. So there's residual milk that can end up in that wastewater as part of that cleaning process, as well as the chemicals, the cleaning chemicals that are used. So sometimes are made up primarily of nitric acid and caustic as well. So a blend of all of that is what's irrigated. So there are some nutrients in that wastewater.
Okay, thank you.
Yvette?
No, thank you.
Thanks, Gary.
Just in relation to the wastewater, I was going to ask the same question actually, try to understand the issue, but in relation, your answer really is about you have had complaints, so it clearly does cause issues. Is it beyond technological advancement to reduce odour, or is that just a given it will always cause odour?
It's very hard to. It's something we find is quite subjective. Degree it depends on the tolerance of neighbours, and we find that rural neighbours tend to be quite tolerant of it, and we find that urban neighbours less so. So,
yeah, I guess my question was more about: is there any technological way it can be improved in the future, the way that it's applied or treated or anything like that?
Yeah, I guess the further you treat it, so you can. What we have at the moment is what I refer to as dissolved air flotation treatment. So that's where you you strip out a lot of the solids before it's irrigated. So you remove a lot of the that organic load, which is where a lot of the odour typically would be associated with. But you can do further treatment steps, biological treatment, tertiary treatment. You can essentially make it potable, clean water if you spend enough money, but you're getting into very expensive territory there. So.
Mr. Llewellyn, just one question from me. So on the boundary that's where the issue is, in terms of that boundary of your effluent field, what's the existing distance to the nearest residential dwelling from that boundary?
That's a good question. Mr. Vikes, would you be able to offer an estimation of that, please? I don't know off the top of my head.
No, Sam, look, I couldn't right now, but I could easily measure that and come back. Yep, sorry.
Yep. Yeah, that'd be helpful. Thank you. All right, but no further questions from me, but thanks very much to the Frontier representatives for coming in, presenting to us and answering our questions. Thank you.
Thank you.
Next submitter is Christchurch City Council. Good afternoon, welcome.
if you're
Yep,
ready.
so-
Yes,
yep,
I'll
over
just
to
make
you,
a
thank
start.
you.
Now, I have appeared previously in the
Yes.
strategic directions topic. Just as a bit of a recap, we filed some legal submissions to start with the hearing topic 1, strategic directions, and also a supplementary set, which responded to a memorandum filed on behalf of the Carter Group. And in relation to this hearing topic, we filed our initial set of legal submissions, and then more recently, on the 19th of November, a supplementary set which responded to the panel's minute, and more specifically the added advice, and also touched on this issue of whether the RPS can be taken as given effect to the MPSUD. So I understand that you've already heard from many submitters on the issues that are of concern to Christchurch City Council, including the Regional Council, which has adopted a very similar stance. I'm not wanting to take you through everything that you've already heard all over again, but if it would help, I'm happy to speak to some of the issues just to try and crystallise them again from a Christchurch City Council perspective.
Yep, that'd be helpful, thank you.
The other point I will note is that we are, well, I'm currently representing Christchurch City Council and the Regional Council on a number of private plan change requests to change the operative Selwyn District Plan. So we're seeing these responsive planning provisions tested at the coalface with specific private plan change requests as well. Now we have heard 3 of those to date, one PC 67, 69 and 73, which are all now pending recommendations from Mr. Caldwell, the Commissioner who's been tasked with unpicking this from that perspective. The information and the evidence that's been prepared by the applicant, and then also the City Council and Regional Council, is also available on the Selwyn District Council website, as well as the legal submissions which have been presented by the parties. Now, they're slightly different in terms of the angle that they've had to take, because they're focused on those particular provisions and the tension, but also the evidence which has been filed around the merits of the proposals. Whereas these submissions are more about reconciling the tension in the policy construct, which is the task that you're faced with. So if it's of interest, we can share those with the hearings administrator, or we can leave it to yourselves to trawl through the private plan change website and find those. I just thought I'd raise that as an observation. So if I were to try and crystallize things, it strikes me as though the legal submissions that have been presented by all submitters so far are on all fours around the statutory and the correct approach to interpreting various documents, and that is that you read the document as a whole document, and then you attempt to reconcile any tension or inconsistencies between 2 different documents. But it's the outcome of that interpretation exercise that's different in this case. What we are hearing from the developer submitters is that the tension that exists between the RPS and the MPSUD warrants giving precedence to the MPSUD over Chapter 6 of the Regional Policy Statement, to the effect that Chapter 5 and 6 are somewhat negated by this new Policy 8 responsive requirement. The legal submissions that were filed by the Birch Road submitters, for example, were that the regional policy statement is effectively invalid and needs to be set aside, and that you have recourse direct to the MPSUD. And then the Carter Group have taken a slightly different stance. They're suggesting that the tension warrants invoking what's called the doctrine of implied repeal, and that you effectively read down or soften the avoid direction in the regional policy statement. We disagree. As our legal submissions would have set out, with both of those 2 approaches. We don't think there is any basis to say that the regional policy statement is invalid and needs to be set aside. And we also disagree that there is an invoking of implied repeal in this case. Now, we filed legal submissions on this relevant to the plan change that was heard last week. But as my friend earlier submitted today, the doctrine of implied repeal is a last resort type situation. It's where you have 2 laws or 2 provisions that try and coexist, where the later in time one has to effectively replace the earlier. Now, there's a factual issue there as well in trying to invoke this doctrine. The timing is such that the NPSUD came along in 2020, that's when it came into force. Change 1 to the RPS has in fact post-dated the NPSUD, and the reporting to the regional council, from the regional council to the minister, has picked up and responded to elements of the NPSUD. So it's not the case that you can say that the NPSUD is a later in time document. As a whole, yes, it is, but change 1 to the RPS has responded to various directions in that through a streamlined planning process that's been completed more recently. So there's a factual issue to contend with on that front, but then you also need to consider the function and the purpose of the provisions that exist in the regional policy statement and the NPSUD. The reason you need to do that is that you have to understand those issues first before you can then decide whether the two provisions at issue conflict in such a profound way that one has to fall away or be softened. And our submission on that is that the regional policy statement objective provides substantive policy direction that captures a range of issues concerning the location and spatial distribution of urban development across this region. It doesn't just deal with urban growth on the basis of capacity. It deals with where you should put it relative to rural character, to landscapes, to groundwater capacity, all of these other issues which you expect to see in a more multifaceted document like a regional policy statement. So it provides substantive direction that covers a range of different bases. When you look at Policy 8 is, as per our legal submissions, an administrative pathway that requires councils to engage with the merits of private plan changes if they satisfy certain criteria. It doesn't provide any substantive direction to approve or adopt these private plan changes. It provides pathway, which requires the councils to consider them on the merits. Now, the MFE guidance, of course, supports that interpretation because it says that this particular policy is designed to stop councils saying no and closing the door to any private plan change just because it doesn't fit with their existing strategic planning. It's requiring councils to engage and assess, but not necessarily adopt or approve. And that's why we say that the doctrine of implied repeal isn't invoked here, because the two policies don't conflict. One's a pathway, the other's setting substantive direction. So that's where the outcome is different between council, regional council, and the developer clients. And it's not surprising that there is this difference of interpretation. I'll come to this a little bit later. The next point is we were asked by the panel to respond to the Adderley Head advice that was given to Selwyn District Council. Just a couple of points on that one. Much of the Adderley Head advice is focused on this issue of timing, and that the housing crisis requires urgent implementation of the responsive planning framework. We make the point in our supplementary legal submissions that there's no reference to a housing crisis in the NPSUD, and there's no reference or requirement that you need to urgently implement the responsive planning direction at all. In fact, the NPSUD does, in the schedules or appendices, set out implementation timeframes for various policies. The intensification requirement, for example, is required to be implemented within 2 years, but the rest of the NPS is as soon as practicable. So there's no clear direction that highlights urgency. And for the responsive planning framework, well, that's going to be engaged in two contexts. I don't think there's disagreement by any party there. You've got submissions on a process like this, and then you've also got requests for private plan changes, which are Schedule 1 exercises. We've accepted that Schedule 1 processes can be engaged here. Selwyn's accepted some of those for processing, and they're running their course. So the responsive planning provisions are being implemented at present. Through decision making on those ones, and also through this review process. So that's fine. That's just the situation we're in. But the suggestion that there's an urgency around this is rejected by Christchurch City Council. The second point that Adley had made, and also other submitters, is that the CRPS needs to be amended. And this is because of this apparent unresolvable conflict that exists between the NPSUD and the RPS. Well, in our submissions, the NPS doesn't say that. It can't be gleaned from the content of this document. While the guidance alludes to removing some barriers or trying to water down hard edges, that's a policy issue. And whether or not there is evidence to support that hard edge is a matter that remains to be determined against the Schedule 1 process and the statutory framework that applies. And again, here we have Objective 6.2.1, which provides a range of substantive directions that capture a multifaceted set of concerns. The developers are running an argument that Objective 6.2 don't have the ability to change that objective, and they don't have the ability to change MAP A. It's a regional policy statement, MAP, and so there needs to be engagement with the relevant local authorities in order to effect changes to that which can achieve their development outcomes. That's why we're here, and that's why we do have this conflict or tension being put forward. Now, the developers know that this is a regional policy statement, MAP, and objective, and yet they are running and seeking these private plan changes to the district plan, knowing that that conflict exists. That's risk that developers are taking on. When what we are saying is that if there is merit in these private plan changes or rezoning requests, there is also the ability to work with and engage with the relevant local authorities to see if there's a broader set of local authority decision-making processes that can be engaged to try and enable or provide for that additional capacity. The reason I mentioned local authority decisions as a broader context is that this is what Policy 8 and Objective 6 of the NPS say. Policy 8 is framed as local authority decisions affecting urban environments. It's not just the one plan change which might seek this out of sequence development. It's a set of local authority decisions which can be interpreted in a broader way. And in the same way, Objective 6 talks about local authority decisions on urban development that affect urban environments are integrated, strategic, and responsive. So the point there is they're stuck in a way because of the RPS and the framework there, but that doesn't mean that there isn't a pathway for these out of sequence proposals. It just engages with a wider set of local authority decisions which need to be made. And where the issue boils down, I had a brief opportunity to listen to my friend Miss Appleyard this morning for the Carter Group, where she accepted that the CRPS in Chapter 6 engages with a wider set of issues than just Policy 8. And she accepted in response to a question, I think from Commissioner Dash, that the issue is not with the line, it's just with where it is. That's really what we're dealing with here. The lines in the RPS, they can't change it. And so they're trying to find a way to jump around it. Whereas we say that there could well be an entirely supportable policy basis for retaining the line and then relying on another set of local authority decisions where it's warranted to move that line. That's an equally valid approach of giving effect to the NPS so that the line can be moved to provide for a responsive approach down the line. There's been mention of the government urban growth agenda. I think from yesterday, I heard the Birch or legal counsel for Birch refer to the government agenda as wanting to remove barriers and enable development up and out. I don't accept that interpretation. The urban growth agenda, one of the 4 objectives of that document is to enable quality built environments while avoiding unnecessary sprawl. what the developer submissions are asking for here through these private plan changes is in fact expansion into greenfield areas. I make the observation that the more you enable expansion into greenfield areas through one-off plan changes, the more you're losing your strategic planning approach to enabling urban growth across Greater Christchurch. The suggestion that Policy 8 trumps the RPS, if that's accepted and is adopted, it is just going to lose sight of the wider, higher level strategic approach to how development is provided for. And it's with that in mind that our submissions deal on or address the issue around Policy 8 being seen to trump strategic planning. The Council's case is that Policy 8 can work in tandem and be complementary to strategic planning. And that's because the local authority decisions that are required to be responsive do cover the field. They're not just limited to plan change. They can also deal with these issues through our space, which has happened recently, and then through the future FDS processes which are required under the MPSUD. I think that's really the overview that I need to provide, and so I'm here to answer any questions that you might have of us.
Thank you, Mr. Wakefield. As with when you've appeared before us before, that's a very concise and well-put summary of the issues from your perspective and the City Council's perspective. So I'll see if we have any questions for you. Andrew.
Thanks, Mr. Chairman. Thank you for your legal submissions and your helpful, I guess, summary around, I guess, some of the key facts and also some of the drivers behind where some of the submitters are coming from your perspective. I do have a few questions, and I think you've elaborated on one of them, but in paragraph 3.4, at the bottom of that paragraph, you said the MPSUD provisions relating to responsive planning, properly interpreted and applied, operate as a separate pathway for allowing merits consideration. So are you saying that the urban growth provisions can remain as notified, albeit with whatever other changes that the officers are recommending, but that a merit-based argument then will come along and people will rely on the MPS and approach local government more widely than simply the council, but also the regional council, and have that argument at that level, and like you say, to move the line at that point? Is that what you're saying there?
Yeah, that's right. We've all accepted that the responsive planning framework provisions do engage with the merits of proposals for out of sequence or unanticipated development. What's maybe unique about this particular region is that the hard line that's causing concern or issue is located in the RPS. If, say, we were operating in a region where the RPS was at a more abstract level and it didn't have map A in it, what you might find is that there might be district plans that have the hard edge and the avoid framework in it. But when you're seeking a district plan change, you would be able to then seek to change that hard line through that Schedule 1 process. You wouldn't be dealing with a regional policy statement, which is out of reach to some degree. And that's where this region is having to face this, and this council in particular. You've got developers who are seeking to engage in the merits at the district plan level, but try and circumvent a hard line, which has been separately assessed and tested in a Section 32 capacity through our space and through a recent RPS change in Change 1. So you're jumping and reliant on this tension when we say that that tension can be resolved through a district plan decision, or sorry, not a district plan decision, but district council buy-in to what the developer is trying to achieve, which then can engage with the regional policy statement through the regional council and the rest of the GCP partners. And look, I note that the NPS does contemplate this wider collaboration between different authorities in Policy 10, where it requires that Tier 1 local authorities that share jurisdiction over urban environments work together when implementing this NPS. We're in an unfortunate situation here where CCC and the Regional Council are having to make submissions to try and ensure that the integrity of the RPS is retained. But what's maybe more concerning is that we are seeing legal advice provided to Selwyn, which escalates or elevates these MPS provisions over the RPS in circumstances where the other GCP partners don't agree with that interpretation. So it remains to be seen how these decision-making processes will play out. But,
So one option then for the urban growth provisions might be to have a policy in there, which is a process policy, which says how the council will respond to plan changes, and also how it may well work with the regional council to consider changes to map A as a result of that, and any other changes to, for instance, its infrastructure strategy. So a process policy. I'm just interested in exploring a line of sight to the MPSUD, so we're not completely silent on it, but also that still necessarily gives effect to map A and recognises the relationship with the regional policy statement. Have you given any thought to that? And I'm not sure whether that's how much value that adds anyway, or it's just simply restating the obvious.
yeah, well, to some extent it maybe is, because you already have that direction in the MPS in any event. So the expectation is there at the higher level document. You can always transpose provisions from higher level documents into lower order documents, but the question is, what is that achieving? Here, maybe isn't achieving much, because it's still going to be the rubber's still going to be hitting the road with this different interpretation that's being put forward by legal counsel around how this tension is reconciled and resolved.
Sure, okay. So for paragraph 517, let's have a look.
Sorry, Angie, just which suite of legal conditions are you referring, which dated?
I think it's the 20 August version.
Yeah, apologies. Thank you, Mr. Chair. So it's just that line in the middle. The reason of this is the MPSUD regime and its responsive planning framework are not expressed in such directive terms as to prevail over the RPS. So what would directive terms look like, just for clarity? Is that specifically say this prevails over the RPS?
Yeah, that's quite right. If there was, if policy 8 was framed as saying local authority decisions affecting urban environments are responsive to plan changes that would add significantly development capacity, and then even if the development capacity is not able to be, well, let me think about this. If there was some text in there which sought to unpick and dismantle the avoid framework in regional policy statements, then we would be more willing to accept that there is specific policy that gives precedence to the NPSUD. But the language doesn't appear in that way through the NPSUD itself. And indeed, Objective 6 puts 3 different matters on an equal footing. It talks about local authority decisions being integrated with infrastructure planning, strategic over the medium and long term, and also responsive. So it puts them on equal footing. It can't be said that the requirement to be responsive can take precedent over those other components in any decision.
Sure. Okay. Thank you. And my final question, 5.36. It's just around where supply is provided at a greater Christchurch level, a district level, or a township level, which has come up in a number of submissions. And then that statement, the if capacity were to be assessed at the local township level rather than macro scale, then it is realistic to expect growth occurring across and around Greater Christchurch, this with growth not aligned with infrastructure planning. So I understand that. I guess my question is, at some point it has to land in a town, presumably, and at some point with the spatial planning exercise, I mean, I'm imagining you don't simply say we need 48,000 households somewhere in Greater Christchurch. I mean, there's some expectations around allocating that to the district, and then if it's allocated to the district, aren't there expectations around where it might be accommodated at a township level?
Absolutely. I mean, that's what has happened recently with the ourspace process. The numbers were assessed and then they were distributed amongst the various districts on a demand and need basis. The point that we were trying to make there is that there is a danger in trying to be responsive, but have the responsiveness framed in a entirely local or township context.
Okay.
The reason we had to make that submission is that we do have private plan changes to West Melton and Lincoln and Rolleston, where they're tackling it from an economics perspective. They're saying the GCP's got it all wrong. The housing development capacity assessment numbers are not accurate, they're not reliable. And we have economics evidence which says that there is demand relative to Rolleston, Lincoln or West Melton that needs to be serviced through these responsive changes. That's fine, they can produce that case, but it's not really the proper forum in our submission to be challenging the our space approach and the capacity assessment. Anyway, that issue aside, the danger in focusing on that local or township frame of reference is that it loses sight of how urban development is to be distributed and serviced across the sub-regional environment. To our mind and from our interpretation, that is why the requirement of the MPSUD is to include criteria that assist with processing these types of applications in the regional policy statement. That's one clear thing about this framework, is that it's the regional council that's been directed to develop and include the criteria in the RPS. There are two ways to look at that. The first is that it puts those criteria out of touch from district plan changes. It means that they sit in the RPS. They can only be changed by the regional and local authorities. But two, it gives those criteria meaning across the whole of the region where the regional policy statement applies. And our interpretation there is that means you've got this broader frame of reference to what is significant development capacity. It's not going to be just about what's significant relative to West Melton. It does require a wider lens.
Yeah, I appreciate that. So you're saying, 50,000 capacity, 50,000 demand, and you started at a higher level, and then you work down and allocate that around where you think it's best to allocate it, as opposed to starting at the local level and saying, right, West Melton's going to grow by 50,000 people, and that's all the demand for Greater Christchurch. Done. Problem solved for the next 20 years. Yeah, I appreciate that. Thank you. No further questions.
Just one further observation on that. I note that Chapter 6 at the moment does include Table 6.2.1a, which I'm sure you're probably familiar with, where it sets out the medium and long-term numbers or development capacity that's to be enabled. So the Selwyn across the medium term, the number is 8,600. In the recent submission that was made by Selwyn District Council on the Housing Enabling Bill, they make the point that they've got 18 private plan change requests at the moment that are seeking to enable 12,000 additional residential sites or development capacity. Now, that 12,000 is well and truly outweighing the 8,600, which is already contemplated within the MAP-A document itself. So we're talking about huge additional numbers of development, which are going to potentially create some fairly significant strategic and infrastructure issues across Greater Christchurch at large. I guess the rubber does hit the road with the criteria, and we don't yet have them yet. But when you're talking about that level of unanticipated and out of sequence development, there's a huge, huge potential cumulative implication for Greater Christchurch at large.
Thank you. No further questions.
Thank you. Lindsay?
Thank you, Mr. Wakefield. As you've rightly expressed, this is a key issue for us with these hearings. A proposition was put to Ms. Appleyard this morning that there might be some form of middle ground. If you like, the policy at the centre of everything is policy P3 in the urban growth chapter, which basically has this word avoid in it. Is it, and from Christchurch City's perspective, is it worth actually exploring whether or not there can be some further explanation of that, or some form of outcomes which could be expressed in terms of out of sequence development? Or is it just you stick with the avoid policy because it's consistent with Plan Change 1?
I didn't quite understand exactly where this middle ground would sit. Would it just involve?
Well, I think the middle ground would put in additional wording about the circumstances where out of sequence development may be considered to be appropriate. So it's an avoid, but if you do X, Y, and Z, you may be a policy pathway through.
Sure. I guess two initial observations on that. If if the word avoid was to drop out, then yes, you do have this potential inconsistency with the regional policy statement to contend with. And what's important here is that you are making decisions in light of the statutory framework that applies to district plans. So you've got to untangle that issue. If you were to look to include new text, which I'm assuming she would have been pressing for the NPS Policy 8 type language to come into this this provision. My observation there would be that if avoid is then subject to an unless set of qualifiers, you would need to ensure that you're not losing sight of all of the higher objective relevant policies and provisions. So again, our interpretation is that the Policy 8 provisions apply in tandem with the NPSUD. They provide a pathway, but they don't trump or take precedence over everything else. And if you were to include that type of language in the district plan, then you're effectively crystallizing the leap to the NPS that skips over the RPS. And as I mentioned this morning, 6.2.1 isn't just about urban growth, really. It's about ensuring that it's in the right place relative to a whole bunch of other different constraints. And those considerations have to come into any zoning assessment that this council is making. Schedule 1 demands that, and Section 75 requires that as well. So I think you'd have to exercise caution to make sure that you're not giving unintended greater weight to certain provisions over others when this objective must give effect to the entire framework.
I think the original position from the Carter Group was that there should be a proviso that it should be otherwise in accordance with the NPSUD. And the discussion with them was more around, well, that's pretty broad. It's a relatively significantly large document. There is potentially some interpretational issues, as has been manifested itself through our discussions in the last couple of days. Would it be worthwhile trying to get the key components out of the NPSUD, which might apply for there to be a merits-based assessment for an out-of-sequence development? And that was the basis of the discussions that we were having this morning. And what I guess the City Council's perspective is that the avoid framework in Policy 3 is directly consistent with the RPS in terms of the Plan Change 1 provisions, which has been through a recent SPP.
Yeah, look, I can understand why they're making that submission or seeking for that drafting change, but it could potentially run the risk of doing violence to the higher order framework as it exists. You've got to think about the function of the NPSUD versus the function of the NPS freshwater management and all of those other relevant higher order objectives and policies. Zoning decisions have to engage with those. It's not only going to be the NPSUD that will be relevant. Policy 8 provides a signal that councils can't close the door. They have to consider these things and give them due attention. But that doesn't trump all of the other relevant direction. And so I think you'd need to be careful consideration to that particular concern. I also note as well that even if you were looking at the NPSUD itself, Objective 6 does put 3 different things on equal footing. Responsible is only one of those. And so if you were going to make reference to avoid, consider amending UGP 3 to bring in some of the Policy 8 factors, do you then need to start bringing in integration and strategic decision making as well? Where does it stop?
Yeah, I appreciate that point. I think the crux of the matter is around the absolute nature of the avoid policy. When you're looking at Policy 8 and in terms of the requirement or the imperative for councils to be responsive to out of sequence development, I think that was their position. And I think what we would really just trying to have a look at was whether there was a way in which you could certainly recognise the PC1 provisions, but there was a framework where which was a lot clearer if for these unanticipated developments. And whether that's works in terms of integration with other parts of the plan, we certainly haven't discussed and haven't worked through, or even whether there is merits in terms of doing it in the first place. So,
No, I understand that. I mean, we did have a similar conversation last week in the context of private plan change 69 with Lincoln, where Ms. Afuiata again was making submissions that relied and drew on some of the guidance that had been issued by MFE. And I can't remember exactly which piece it is, but one of the guidance documents talks about the expected outcomes of the responsive planning provisions. And there's internal inconsistency in the guidance itself, which perhaps isn't very helpful for any of us when we're trying to understand and interpret the documents, but it does refer in one section to strategic planning exercises identifying areas that then must give effect to the responsive planning policies themselves. Now, what we take that to mean is that through spatial planning exercises like our space, you can end up with areas which are urban environments and zones, and you can also end up with areas that aren't zoned but are contemplated or anticipated for development across various periods. Auckland has one of those examples with the future development areas that have allocated time periods to them. So the strategic planning exercise looks at the broader picture and considers where is development going to be over the next 30 years. It might not be enabled through plans, but those responsive planning provisions can then be used to try and bring forward development in those areas. And so when the guidance says that spatial planning and the identified areas must give effect to those, we understand that to mean that the responsive planning frameworks can be used relative to what the spatial planning exercise might identify. And there's comparable situations here with the RPS having now identified future development areas. They're not zoned. Half of them aren't even the subject of any plan changes seeking to in fact zone them for urban development. But the responsive provisions can clearly be used to try and bring them forward because there's no clear time period around those. And so to some extent, the outcome that the NPS is trying to achieve is in fact already delivered through the RPS. It just doesn't go to the ends of the earth, which is what some of these developers who sit on the other side of the line are concerned with.
Okay, thank you. That's been most helpful.
Malcolm?
No, thank you, Mr. Wakefield. Thank you for your evidence and your interpretation. As you say, it is a matter of interpretation, and it is taxing. It will be taxing our mind for the next few weeks. So, thank you. I have no other questions.
Thanks, Nicole.
Yeah, back Malcolm's comments. Thank you, and I've got no further questions.
Thank you, Deborah.
No, I've got no further questions either.
Mark?
No, thank you.
Raymond?
Nor me.
Is it?
No, thank you.
Gary?
Yeah, just quickly, there's been a lot of discussion. I don't want to labour it, but I was interested in your comment that your submission that the NPS doesn't stress or require urgency. I think you made that point quite strongly. My first observation is that would it not be implicit that there is at least some urgency in delivering the outcomes of the NPS? And on that note, the MAP-A, we've heard a lot about MAP-A. We heard yesterday that its genesis goes back to about 2006, 2007, and it will require updating. And I'm wondering what time frame would the NPS envisage would be appropriate for updating of the CRPS, even if it's not ultra urgent. What would be an appropriate time frame, in your view, to give effect to the NPS?
Yeah, that's a good question. I mean, my comment around the timeframes or the urgency was really a response to the Adderley Head advice, which, in our mind, interprets the NPS UD when framed against the housing crisis and the need for urgent release of land. We're not convinced that the NPS provides or provides for that interpretation, which is why we made that suggestion. but we do accept that the responsive planning provisions are able to be relied on now, and indeed they are. So there is a more immediate response as a result of those provisions, but there's no substantive direction that says that councils must do things immediately. So there's a nuance there which might have been glossed over. In terms of the RPS component of it, the MPS doesn't set any directive timeframes for any review of RPSs or district plans. It's really going to be decisions made by local authorities which choose to bring forward components of their RPS review or district plan review as they choose to. I suspect that if the district councils in this region or any other regions put increasing amounts of pressure on regional councils, then they might be able to then get that process brought forward. Here, this region has historically, and particularly since the earthquakes, been the subject of some collaborative planning with the Greater Christchurch Partnership. I'm aware that there are discussions between the GCP at the moment around the next round of spatial planning exercises which are being developed at the moment. So whether that's going to be brought forward as a result of these types of hearings, I'm not sure, but the reasonableness of any time frame for a review is, I suspect, firmly within the powers of local authorities to determine.
Thank you for that. And just finally, you mentioned the private plan changes that are underway at the moment, and there's quite a number of those. And I thought I understood you to be saying that's a planning response, or that's an appropriate, that's the normal course of events, and they can each be considered on their merits. Is that really an appropriate planning response? Because the merits assessment will go back to the CRPS, won't it, and have some sort of barriers to success, I would have thought. Is that an appropriate response, or should we be doing more than that?
Well, that's music to the city council's ears, but it's certainly not what the developers are submitting. What I meant by that is that we do have these private plan changes being requested, but they're being requested on the basis that the NPS trumps or takes precedence over the RPS. So they're saying that Selwyn District Council can approve this by reading 6.2.1 as a void unless the NPS allows the granting of these plan changes. And regional council and city council are making submissions and opposing those on the basis that approval of those private plan changes and rezoning land outside the PIB or the GPAs or FTAs would lead to inherent inconsistency with the regional policy statement. And so it's taking the NPS, jumping the CRPS in favour of a responsive approach, which isn't properly integrating or strategic as the GCP has intended development to be.
So that's what you would call a merits assessment.
Well, it's assessing the proposal on the merits, but our argument on those proposals is that the statutory framework won't allow the approval of them because you'll then lead to a non-compliant district plan.
Just two matters quickly. Just following up on that issue of the private plan changes, and I imagine, and as you've said, and as we've heard from other submitters, there's PC 73 for Olliston, PC 69 for Lincoln, and there's a West Melton one as well, which decisions are expected shortly, if not before Christmas. Now, imagine if those plan changes are granted, then yourself and the regional council would appeal them. But putting that to one side, if those plan changes are approved, don't they result in a de facto movement of the MAP-A hardline?
Well, if they're allowed to stand, then yes. And the situation then becomes you've got the lower order district plan driving the spatial planning exercise and the amendments to the RPS. So you'll end up with the tail wagging the dog. You'll have this multitude of private plan changes, all rezoning land outside the GPAs and the FTAs, and then through the next round of the RPS review, I'm sure you'd expect the RPS to see these areas picked up and brought within those urban environments. So you're losing, and this is why I made the point earlier, the more you decide things on a responsive basis, the potential is there that you lose sight of your strategic spatial planning exercise that you're required to do. And the MPS is very much focused on good local authority decisions that achieve integrated and strategic outcomes. That's why they put those two things on an equal footing with responsiveness. They're all working together to deliver a sensible outcome.
Yep, no, I understand all that. I just wanted to get your response to the fact that we might be seeing a de facto revision of map A anyway through a result of these private plan change decisions.
Well, if they were granted, then yes, that's of course the case. But at
Yeah.
the same time, you'd be ending up with a district plan which doesn't comply with the RPS.
And we've heard that the criteria that are going to be slotted into the RPS to define, significant development capacity aren't going to be notified till 2024. And is that your understanding as well?
That's information from the regional council.
From some submitters, I can't remember who said that, but someone has during the course of the hearing said we're unlikely to see those in the public domain before 2024.
I don't know if that timing is quite right. I don't want to, I'd have to defer to the regional council to provide that information. My understanding was that the full review of the RPS would be notified in 2024, but that the work around these criteria is already underway.
Yeah.
So I'm not sure whether or not there is any intent to bring forward the inclusion of the criteria in advance of the RPS review.
Yeah, we heard from the regional council yesterday, and I may be getting confused with who's spoken to us about what issue, but I thought they said that there wasn't an intention to do anything prior to that.
Right.
They want to roll it all into one process. But if that is the case, and then of course there might be appeals to that, we might not have finalised criteria for some years after that, which we're looking at an MPS Policy 8 vacuum for potentially quite some significant amount of time, maybe 4 or 5 years. Isn't it behoving on us to try and address that vacuum in the meantime in response to submissions that we've received on the district plan?
It's probably two ways of looking at that. That's maybe a timing issue as well. For example, these private plan change requests that are currently in train aren't able to be approved because of the misalignment that would result with the RPS, then you might not need to, because they won't be able to give effect to the statutory framework, and there'll be no pathway for these out of sequence proposals until the criteria are included in the RPS. If some of these private plan changes are granted and the Environment Court potentially upholds them, then that might mean that there is a pathway despite the RPS Chapter 6 framework. And it could well be of benefit for the district plan to include those criteria. So I think I can't provide you with the answer, but you understand what I'm saying there.
So we should keep an eye on these private plan change decisions, and if the commissioner grants them, we should be thinking about what we might need to put in the district plan in that regard.
I think that's right. My other observation there would be that, again, it's a sort of a tail wagging the dog type scenario where the district plan hasn't been directed by the MPS to include these criteria. It's a regional council requirement. So caution would have to be taken to ensure that whatever criteria are being developed within this Selwyn district plan cover the field in terms of the regional, sub-regional growth imperatives, which are being, which are required.
Understand that. Whatever we do, we wouldn't want to throw out the strategic baby with the bathwater. I understand that. All right, thank you very much. As usual, your answers to our questions have been very helpful. So thanks for taking the time to come in and speak to us this morning, or this afternoon rather. So, where are we at? Yeah, we're at lunch. So we're running half an hour behind time. So we will still, though, adjourn and reconvene at 1:30. We'll just have a shorter lunchtime. Thank you.
How are ya? I made myself a banana sandwich and was cramming it down because half an hour's not long.
We're not live streaming yet, are we? We're live streaming, Raymond, just for your information.
Gosh.
So there's now a global understanding of your dietary preferences.
Yes, yes, I've got to be careful.
It's not their relationship. What have I done wrong?
Yeah, imagine.
No.
Right, good afternoon, everyone. We'll resume the hearing of submissions on the urban growth chapter of the Selwyn District Plan. At this stage, we're hearing from Waka Kotahi, NZTA. Good afternoon and welcome. So we have the pre-circulated evidence from Selina Lai and also Stuart Pearson. And is that the only information we should have in front of us at the moment? Is there any additional documentation?
No, it's just everything that was circulated prior.
Excellent. Thank you very much. There's been a little bit of confusion with stuff that's been tabled and hasn't been tabled. So I just wanted to clarify that. So I think you've appeared before us before. You understand our process. We've read the pre-circulated information, so you don't need to read that out loud, but you're very welcome to summarise key points, and then we'll see if we have questions for you.
Cool. Hi, everyone. My name is Stuart Pearson, and I help produce the planning evidence on behalf of Waka Kotahi, and had some involvement in the original submission, further submissions for the Selwyn District Plan. And I have Selina here as well, who also produced the evidence, and I've also got Stuart Fletcher, our consultant planner, who also supported us throughout this. But yeah, happy to answer any questions you may have.
Excellent. All right, we'll see if we do have questions for you. Are you happy if we would you prefer us to ask questions of you first and then of Ms. Lai, or just questions generally?
Questions generally is okay.
No, that's good. We're happy with that. So, Andrew, questions for Waka Kotahi.
Thank you, Mr. Chair. Thank you for evidence, Mr. Pearson. My question is an unusual one, actually, and it's a very simple question. I'm just curious, you're a member of the New Zealand Planning Institute. What category membership is that?
Currently still a graduate, but
Graduate, thank you.
Working on the intermediate status.
That's good. So that's great that you're progressing through then. Yeah, thank you. And that was all. My only question, actually.
You're right. That was an unusual question. Lindsay.
I don't. The evidence is very clear. I don't have any additional questions. Thank you very much.
Malcolm.
Neither do I.
Nicole.
Neither did I, so thank you.
Deborah.
No, nor did I. So thank you very much.
Mark.
No questions, usual or unusual.
Yvette.
Kia ora, no thank you.
Gary.
No, I haven't. But I'm wondering whether we should. I'm wondering whether we should give the opportunity just to recap what relief you might be seeking. I mean, that you're in substantial support of the 42A report. Is there anything you'd like to draw our attention to that you'd like to see changed, or is it simply a case of you're pretty happy?
Pretty much when I was reading through the Section 42A report and comparing it with our original submission, I understand the reasons as to why our points were rejected, and that was stated very clearly, and we've got explanations in that 42A report. So Otherwise, we're very supportive of the other recommendations made and other submissions made by other people that were accepted by the Selwyn District Council. And yeah, no, we're just generally supportive of this chapter.
Okay. During the course of the hearing, we have had some presentations that relate to infrastructure and, you know, reasonably important infrastructure, such as, and I guess such as state highways and so forth. And all I can really say is our observation is that those matters are not contested, or they're certainly they're part of the provisions, you know, protection of the assets. So I understand the evidence. I'm not going to ask any particular questions, but I'll just make that point.
I also don't have any questions of clarification with you, which makes me somewhat embarrassed that I hadn't checked with the panel members that we did have questions before you made the effort to come in. But I think what that shows is your evidence is clear. We clearly understand the points that you've made, and so there's nothing we need to clarify with you. So appreciate the time you've taken to come in, and enjoy the rest of your afternoon. Thanks. Sorry, just want to flick your mic. No, sorry, just your microphone. If you can just turn the microphone on and maybe pull it towards yourself a bit.
So I have with me Mrs. Springer, the submitter, who owns land in Prebbleton, and she's here to answer any questions that I can't. So, I assume you've all read the statement. I don't intend to elaborate on anything. I think hopefully it's clear, but just to say, I think this is a procedural matter. The substantive issues will be dealt with at the rezoning hearings, and really the purpose of being here is just to clarify that I just think the officer's recommendation is perhaps incorrect, not because of the officer necessarily, perhaps the way the submission was structured. And so we just wanted to make sure there were no misunderstandings of the position prior to the rezoning hearings. I think that's really it.
All right, thank you very much for that. And Ms. Springer, do you want to say anything at this stage?
No, thank you.
All right, that's fine. Andrew, any questions?
No, none from me. Thank you for setting out the matter and the issue and how it's proposed to be dealt with through the different hearings. Thank you. Thanks for coming in.
Thank you. Lindsay.
Only just a little bit more clarification around your paragraph 8 about this MUL limit issue, and it's been in and out. Can you provide a bit more context to that?
Yes, well, the history of that is in the original submission. I didn't print that off, but there are two letters there, and it sets out the history of how the MUL has variously been located across this boundary and then outside it. So, as you all know by now, that MAP A has gone through a sort of series of hearings, starting with the original MAP A through the LERP, and then through our space. And there's been, so as a result, the MUL was one, I think it was in 2009, was originally through the property. It was then in the Prebbleton structure plan reflected that. And then since then, once I think the LERP came out, it was outside, and then the submissions on our space were unable to move it, so it stayed outside, and it's still outside. And I guess that my comment on that would be, it would reinforce what I said yesterday about Map A. It's a situation where properties like this and meritorious planning proposals of this size cannot move because Map A is so rigid because of the avoid policy. So, Commissioner Nation, I think that's gone on a wee bit about that, but hopefully that answers your question.
Yeah, thank you for that. No further questions.
Thank you. Malcolm? Oh, here's two. Sorry. So I should have announced that one of our commissioners has declared a conflict of interest, so I won't be taking part in questioning at this stage. Thanks, Mark, for reminding me of that. Nicole?
No questions. Thank you.
Deborah?
Yes, I just have one, and thanks very much. And it's around the history of this particular block. With regards to the LERP and basically the rural residential strategy that came out of that, was this piece of land able to be considered under the rural residential strategy? Just for clarification, just trying to clarify.
No, I don't think it was. No, I'm not aware of that was part of a rural residential strategy.
And looking at the map of where this land's located, it's actually surrounded by residential. And
True. Yes, it has on two sides, and then you've got an urban type use to the north. So what is a vet or something?
then we talk about
a
hard line. Who the areas that are natural. Sorry?
Sorry, I couldn't hear that.
Sorry, I've got an unstable connection at the moment, and I don't want to turn off my computer and reboot it. So can you all hear me now?
Yes.
Okay, so my question, I'll go back. This area, looking at the map, seems to have been sort of an area that's left that we could, it could be considered that infill would actually make a more coherent planning regime for Prebbleton with regards to where it's located. But we've also heard the argument about the hard line that Map A has, and this is outside of it. Just with regards to the way that we've heard the information today about regional policy statements and policy 8, and the overlay plan, I'm just trying to think, would this be a high priority in your understanding with the overlay map, that if extra was to be considered, that this would have a higher priority over private plan change requests that are currently being heard from a planning perspective?
Well, I can only really comment, Commissioner Hassan, on the context of the review, and I probably have to go back to the criteria which is in the rezoning framework, and that criteria, from my recollection, makes provision for this. It's outside Map A. It's not in a greenfield priority area. It's not in an urban growth overlay, and therefore, and it's a small piece of, it's an anomaly or those kinds of words. So it's up to the officer's discretion, I think, is the way those criteria work at the moment. And I don't want to foreshadow what the officer's recommendation may be, but I suppose to get to the answer, I'd say that this sits beside a number of others I can think of, which would be fairly easy for a future panel to consider. But of course, you need the merits evidence as well. So I don't want to foreshadow the merits of this. That it does seem to fit the criteria that's in your office's reports and the rezoning framework.
Right. No, That's what I wanted to understand. So thank you.
Mark?
Thank you. Just having a look at the property in question on our E-plan, for the proposed plan, it also seems to be under a noise control overlay, which I suspect is a historic one from the railway. And that might be an underlying reason that it was excluded from the urban limits, is that there was a historic noise overlay because it would have been historically next to the railway line. So I'm just wondering whether the officers perhaps could report back to us on whether that noise contour is in fact appropriate there now, given the railway doesn't go there anymore, because that might be one of the reasons that historically that it was omitted from the metropolitan urban limits of Prebbleton and the growth overlay. So thank you for bringing this to our attention. It is one of these anomalies that happens from time to time, but if we can resolve that, it might be some relief available. I'm not going to forecast what may or may not happen, but there seems to be another reason that it may have been omitted.
Of course, thank you.
Raymond? Raymond?
Yes, I just want, I'm looking at your figure 1 that shows the outline of the property, and I'm trying to figure out where the property is in figure 5.
Right, figure 5.
Figure 4, sorry, figure 4.
Figure 4, yes, the blue dot somehow got lost in translation. That was on there, or is it? And I can't explain why that's not on there, but I think Margaret, it's that line. That's bisects it, doesn't it? That line bisects it.
That's right.
Yes.
Goes,
So it's just outside. It's just outside. I think it goes. It's here, isn't it? We just get to refer back to the other photo actually, but I think it's split. That urban limit splits the site. Then the Prebbleton plan goes through the middle.
So Ms. Thompson, you just correct me if I'm wrong. So Raywin, if you're looking at that figure 4,
yeah,
and do you see there's a label called Springs Road up near the top of the page?
Yes.
And see just below that there's a thick red line.
Yes.
That bisects the property.
Bisects the property, that's correct.
Right.
So the property is that kind of upside down L shape that thick red line goes through.
Yeah.
Is that correct?
Thank you. Thank you. I can see it now. That's all from me.
Thanks. Yvette?
No, thank you.
Gary?
No questions, thanks.
No questions or clarification from me, Ms. Thompson, but thank you very much for coming in and for clarifying that issue that was raised by the 42A officer, that in fact you're not seeking that the overlay apply to this property, you're just foreshadowing what will be discussed at a later
that's correct.
rezoning hearing.
Yeah.
But I think it was worth clarifying that in terms of the advice that's currently before us.
Yeah.
Yep.
Thank you.
Thank you very much for coming in.
Thank you.
So that brings us to the close of this part of the hearing. We have no more submitters to hear from. The next stage in the process is for us to receive a reply report from the Section 42A reporting team. So just in terms of that, and things that we may have raised during the hearing that we've asked you to address, either directly or indirectly, is there anything you'd like to clarify with us in terms of where you're not sure what we might have asked you to address?
It might be easier if I can outline some of those questions and just get you to confirm that I've covered everything that you
Sure.
asked. Yeah.
Do you want to do that now or do that in writing later on?
Potentially in writing. Yeah, just have to go over all the notes. Double
Yeah,
check.
that's good.
Yeah.
So if you make a list of the things that you've noted to include in the reply report, and we'll see if there's any additional matters that we'd like to include in that report, that'd be really helpful.
Sure.
So just in terms of timing, then in terms of getting that list of issues to us, what would be the rough timing for that, do you think?
Maybe in the next couple of days. Yeah.
Yeah, that's fine. And then after we've confirmed or added to that list, would it be a couple of weeks that we'd get the reply report, or would you need longer than that?
Yeah,
Christmas.
basically is. Well, put it basically at Christmas time anyway, right?
Yes.
Is this what you want to read over Christmas time? Is it?
Not really. So.
You want it before? Yeah.
And
Maybe
is it
after
still okay? So we might get something early in the new year. And is it still the intention to attach legal advice to that?
Yes, I was going to ask if there were any specific legal questions that you may wish. Otherwise, we can ask Mr. Rogers to respond to any of the supplementary legal advice that was provided throughout the hearing.
Yeah, that'll be helpful. And perhaps when the list of issues comes out, the panel members can think about any legal matters specifically that they'd like addressed. We could just add those into that list. I'm sure that'll be on his list. So Gary's just reminded me of that proposition I put to Joe Appleyard about UGP3, but I imagine responding to all of the submissions and our propositions on UGP3 will be included in your list of issues. Yeah. Yeah. Excellent. All right. Thanks very much. So we'll close